Lordship, an IA, my lord, for the 29th of my lord May, my lord. This my lord, this IA was, my lord, has been filed by us, my lord. I am for the applicant. We are the respondents in the RERA appeal, my lord. The RERA appeal was listed last on 23/5. What has happened is, my lord, in the RERA, my lord, the adjudicating of the execution has been kept at abeyance because the RERA appeal has been filed last year. So, my lord, the matter has not been listed for a long time. So I pray that the IA may be taken up, my lord, on 29/5, if possible, ma'am. 29/5, Thursday, ma'am.
Why?
Lord, some urgency is there, ma'am, because it has been kept in abeyance, my lord, actually, my lord. The execution,
Thursday is for High Court,
my lord. Any other day, ma'am. Any other.
35.
30. Deeply obliged.
May please, Your Lordship. I beg for listing of a FAO matter for orders, Your Lordship. FAO matter for orders, Your Lordship.
You want it tomorrow?
No, 28/5, Your Lordship.
Then mention it before that court. There's no urgency.
In the meantime, there is a compromise in between the parties.
Fantastic. Then you don't need to mention it all.
Deeply obliged.
No, please, Your Lordship. I beg to mention item number 10. In item number 10, Lordship, we have challenged the appointment of respondent number 5. It's a private respondent. There is no stay. It's a private respondent number 5. So there is no stay order. We have taken Dusty, he refused. So in the meantime, Lordship, I made it an accident and lost the copy of the Dusty also. And if your Lordship permit me to take fresh steps through registered post, Lordship. There is no stay order, Lordship.
Mr. Counsel, are you aware how this court functions?
Lordship.
I don't give these permissions at that mentioning out.
Lordship. I apologize, Lordship. Lordship.
May please, Your Lordship. I pray for listing of a RSA matter for order 41 hearing.
Tomorrow? Why?
Not execution court has already proceeded.
To file an application on the order 21 Rule 29. Mention it tomorrow.
Highly obliged.
For motion item 1.
Yes, what is this?
May please, Your Lordship. There is pertaining to compassionate appointment, Lordship.
Huh?
Compassionate appointment, Lordship.
When did the person die?
Lordship, what happened, Lordship? He died in the year, Lordship. Initially, he took voluntary retirement, Lordship, on health ground, Lordship.
Then?
And subsequently, he died. Thereafter, after 1 year,
He had taken voluntary retirement.
voluntary retirement on Lordship 30/11/2021, Lordship. In my synopsis, Lordship, second paragraph.
Voluntary retirement on 28/4/2019.
28/4, his date was retirement was 30/11. Voluntary retirement was, Lordship, 19.
So then how do you get it? Compassionate appointment, retirement person gets it?
Lordship, voluntary retirement on health ground, Lordship.
Show me that. Where is that scheme?
Lordship, I thought Lordship would be no.
Then it's provision.
This is guidelines, man. High Court notification. High Court scheme 2017.
How do you come within the ambit of this?
Lordship, because he had 3 years of residual period, Lordship. The order that government order that your Lordship had set aside, Lordship. Because of that order, he could not apply at that period of time, Lordship. Otherwise, he could have applied, Lordship. And subsequently, your Lordship had set aside that order. So,
No case. No case for compassionate.
He mentioned
Voluntary retirement you have given and you got it on when?
28/4/2019.
2019, Lordship.
Yes. But due to his health related issue, he prayed for VRS on air, which was subsequently granted. When was it granted?
Okay, it was in 28/4/2019. He was with effect from 28/4/2019.
No. It was granted when? He prayed for VRS on 28/4. This is what is mentioned out here. And nowadays you have that day you produce me,
Yes, ma'am.
where's that?
Yes.
Now the question does not arise. This
Yes,
type of
ma'am.
thing.
This one, my lord.
You don't have any right out here. This. This has been discontinued then. And this was discontinued on 19th of April 2018. Then what right do you have?
Lordship, I may allow to go through the,
Take it. And we dismiss it right away.
Lordship,
This
one
type
week
of
time,
cases,
let's
this
come
type
next
of cases, Mr. Bhagavati, no case. And I don't have the habit of giving direction for consideration. You don't have a right.
Lordship. Yes,
Withdraw.
I was not aware of it. Lordship,
Withdraw.
I would like to request.
You are dismissed.
Withdraw.
Don't do. Heard Mr. M. Bhagavati, the learned counsel appearing on behalf of the petitioner, Mr. G. Bushra appears on behalf of the Guwahati High Court. Pusto. The present petition has been filed, being aggrieved by the non-consideration of the representation submitted on 15/3/2023 by the petitioner to the Registrar General Guwahati High Court for appointment on compassionate, on the ground of compassionate, for appointment for compassionate appointment. Pusto. It is relevant to take note of that the father, is it father?
Lordship, his father.
The father of the petitioner had retired, had taken voluntary retirement in the year 2019. Pusto. Pusto. It is further relevant to also to take note of. No, it is relevant to take note of that the father of the petitioner had expired, had retired, had taken voluntary retirement in the year 2019. Pusto. The scheme for compassionate appointment for Guwahati High Court, principal seat in the district court establishment of Assam, dated P1/2017, have been discontinued with effect from 19/4/2018. Pusto. Upon this notification being shown to Mr. M. Bhagavati, the learned counsel for the petitioner, he submits that the petitioner would not press the instant petition. Consequently, the instant petition therefore stands closed on withdrawal.
Public. That's all right.
For admission item 2.
So your lordship's last order.
Oh, yes.
Salary for that.
September 2018 to December 2019. My lord, after your lordship's last order, my lord, initially nothing was there in the main register. I asked the CGM that you do a rigorous search and you see whether there is any proof of their engagement. They got hold of 2 registrar wherein their signature are there for that particular period. So they'll be entitlement for salary for that September 2018 to December 2019.
September to, which is to the tune of rupees 1,44,000.
Yes, my lord. That is.
Yes, Mr. Gogoi.
The document in the repetition is page 49. The sanction is there, my lord, till 2021. So he was working at that point of time and the financial sanction.
No, therefore I was saying the sanction was there. The problem is being created by the CGM concerned. And he has filed an affidavit falsely before the court.
No, actually that para 12 of the affidavit had come because they gave me the instruction seeing the normal regular register. There are
But
another register.
don't you think that if it was another government servant, if you have taken it, we would have been very strict on that?
Yes, my lord.
And the CGM has taken it for a right for this court unnecessarily. This matter has been pending from 2021 unnecessarily.
My lord.
Should we not deprecate his, what he has done and make him a party by name and then ask him to show court?
That's true.
Because the Supreme Court otherwise says not to pass any orders without hearing him. So
Yes.
we should hear him in person and why he has submitted a false affidavit before the court. So ask your officers next time to be more
Sure.
careful till this court holds this bench.
I convey.
Others is I'm not concerned.
Yes, my lord. I'll
We
surely
ask them to be very, very careful.
Yes.
Not to file this type of affidavits. Heard Mr. S. Kandal, counsel appearing on behalf of the petitioner. Mr. H.K. Das appears on behalf of the respondent number 3.
1 and 2 I'm going.
And Mr. B. Gogoi appears on behalf of the respondent number 1 and 2. The petitioner herein has approached this court by filing the present writ petition seeking a direction for release of his arrear salary oblique remuneration from the month of September 2018 to December 2019, that is for a period of 16 months amounting to rupees 1,44,000. The petitioner further have sought for a writ in the nature of mandamus that the petitioner should be regularized in his service in a sanctioned grade 4 post. At the outset, Mr. S. Count submits, you don't, on regularization, you are
Because I
not,
was discharged from August 2022.
at the outset, Mr. S. Count submits that as the petitioner was discharged from service with effect from August 2022, the petitioner would not like to press the second prayer as regards a regularization of his service. First, however, he submitted that the petitioner was performing his duties as directed from the month of September 2018 to December 2019, and for which the petitioner is entitled to his arrear salary, which has been unduly withheld. Full stop. This court further takes note of the order passed by this court on 1/5/2025, wherein this court in view of the statements made in paragraph number 12 of the affidavit in opposition filed by the respondent number 3, the effect that there were no materials available that the petitioner was engaged from September 2018 to December 2019, sought for instructions from the Standing Counsel for the Guwahati High Court as to on what basis the statement is being made at page number 67, as to what basis the said statement has been made, more particularly in view of the enclosure to page 67 of the affidavit in opposition filed by the respondent, page 67. Page at annexure R2 of the affidavit in opposition filed by the respondent number 3. This court further inquired with Mr. B. Gogoi, the learned standing counsel appearing on behalf of the respondent number 1 and 2, as to whether there was any financial sanction granted for the engagement of the casual employees in the Chief Judicial Magistrate Bongaigaon during that relevant period. Mr. H.K. Das, the learned counsel, submits that after the order being passed by this court on 1/5/2025, whose rigorous search was made, and thereupon it was found in the which registers?
Yes, two registers.
In which registers? Name?
Contingency, attendance registered.
In the contingency attendant register and
Look, it's same thing.
in the contingency attendance register, that the petitioner was duly working during this period from September 2018 to December 2019. Full stop. Mr. B. Gogoi, the learned counsel appearing on behalf of the Finance Department of the Government of Assam, drew the attention of this court to page 49 to annexure 18 of the writ petition, and submitted that during this period there was financial sanction of 5 numbers of casual employees in the establishment of the Chief Judicial Magistrate Bongaigaon. First, taking into account that the petitioner had been performing his work, had been discharging his work from the month of September 2018 to December 2019, and there was financial sanction in that regard, depriving the petitioner of his wages, of his dues, violates the mandate of Article 14 of the Constitution. Consequently, this court therefore disposes of the instant petition with the direction to the Chief Judicial, the respondent number 3.
Judicial Department, it has to come. Respondent number 1.
The direction to the respondent numbers 1 and 3
Yes, Madam.
to take effective steps so that the petitioner is paid his dues for the period from the month of September 2018 to December 2019. Full stop. The said exercise be completed within a period of 2 months from the date a certified copy is served upon the respondent number 3. Full stop. With the above, the instant petition stands disposed.
I may be also granted liberty to approach the concerned authority because I was discharged from August 2022. There's another period which is not paid because after the filing of the case, that period is not paid. So I may approach the authorities.
Counsel, we are only here.
There,
Representation of
and there's an IA which is pending, my lord,
I for what?
for implement, my lord.
Of?
At the High Court, that was allowed. So IA can-
I stands closed.
Item 3.
What is this?
This pertains to selection,
Huh?
selection to the post of peon in the establishment of district and
Selection to the post of peon.
peon,
Where?
district and session judge for Kamrup.
Kamrup.
There was an advertisement Malad, for 3 posts. Malad. One post was reserved for the persons with disabilities. Malad.
Ah.
The petitioner being a person with disability applied, Malad, and he was asked to appear in the examination. Malad, will you kindly come to page 26, Malad.
What are you challenging?
Yeah, process.
Why? You didn't get it?
No, Malad, the respondent number 4 was she was appointed, my lord, but she applied for the post of she applied under the category of ST planes. but she was given under the category of persons with disability. Thereafter, the respondent have come up with an affidavit, my lord, saying that she originally applied for persons with disabilities, and that was intimated to the authorities, my lord, after the exam was over, after the interview, my lord. And she was called for independently. She was called for an interview after the interview was held, my lord.
Then
If I may show it from the records, that is the case.
is the person, respondent number 4 is a person with disability.
She is a person with disability.
Then why should we interfere?
Only for, okay, what?
Are you above the merit in person in disability with the respondent number 4 or not? Tell me that.
petitioner
Mr.
secured 34.
Counsel, this court is not going to exercise 226 unnecessary. The reason you has to be very clear. Scope is very limited.
Fine. That I
Therefore, the question is, two questions which I'll put you. First, as to whether the respondent number 4 is a person with disability? Yes. Secondly, are you higher in merit in that category? No.
One thing, my lord, will kindly see, my lord. The examination, if I may take a look to the page, my lord, page 26. My lord will kindly mark the dates, my lord.
Not necessary. Yes.
Page 26, my lord, then this is the notification calling the selected candidates for interview. It was issued on 26 June 2023, saying that the examination will be held on 2/7/2023. After this examination on 2/7/2023, he sits in the examination, my lord. At page 27, my lord, will kindly see serial number 6. It is shown, my lord, respondent number 4, Monumita Rabha. She applied under ST planes. Thereafter, she was given under the category of persons with disability. She came to know that her name has been reflected under the category of ST planes, my lord, on 26 June. Thereafter, she sits in the examination on 2nd
Where is your name?
34, my lord. 36.
36. Suraj Kumar Boro. Huh?
No, my lord. Serial number 11166, page number 36.
Page number
Page number 36,
166.
66, serial number.
Where is that?
Page 36.
Page 36, 166.
What is his name?
Sobhin Thakuria.
PWD.
Yes.
Then
What I am trying to project, man,
Hmm.
is that the respondent number 4, she was aware that her name has been reflected in the category of ST planes on 26 June 2023.
Hmm.
And after that, she sits in the examination on 2/7/2023. She does not raise any objection, my lord.
Hmm.
She raises the objection, my lord, on 11/7/2023. Thereafter, my lord, in their affidavit, my lord, if my lord comes to their affidavit, page 57, paragraph 8.
Hmm.
Am I with your lordship, my lord? Page 57, para 8. If I may read it, my lord. The answering respondent, while denying the contentions made therein, begged to state that respondent number 4, that is Srimati Monumita Rabha, applied for the post of peon in the standard form. However, the office of the district and session judge Kamrup had inadvertently shown her name in the ST planes quota in the notification dated 26/6/2023.
now, what is the difference in selection procedure?
Pardon?
What is the difference in selection procedure between an STP and a PWD?
No, there is no difference in selection.
Then how is it, why should this court exercise 226? There has to be a failure of justice.
See, after the examination was conducted, examination was conducted 2/8/2023. I'm sorry, my lord, on 11/7/23. Thereafter, she gives the application that my name has been wrongly shown. Thereafter, she was called for an interview separately. Only she was called for the interview without intimating the selected candidates.
What
She-
right do you have to be intimated again?
Well, is it, she
Is
has been,
it required to be intimated again? Where's your right?
but she has been asked to see.
Understood.
Yes.
So therefore, are you alleging malafide against these officers?
I'm saying, is it a fair administrative play, my lord?
So
Being called after the examination was over.
understood very well. So if you see that she was done behind the back of you, what right do you have? The selection procedure is as per them, how they do it. Yes, if it is grossly illegal, this court will interfere. Not in this case. No case. Stays there.
I'm sorry?
Stays there.
No, sir.
Working.
The only question what I feel to be required to be appreciated is whether she can be called for an interview after the examination is over. She is called for interview independently. No one else is there.
Why should you be called again? Yes, it was a mistake committed by them.
Fine.
In the selection proceedings, they should have put her also in the list of PWD, which they did not. But what right is affected by you? Are you there in the list?
List of,
Means, are you selected?
but I'm in the waiting list. Well,
Oh.
they give a waiting.
Where is the concept of waiting list nowadays? Huh, Mr. Das? How can there be a waiting list in view of the AFRBM Act?
Yes,
Isn't it, Mr. Where is the finance? Any finance? No person. In view of the AFRBM Act, the concept of a waiting list is foreign.
it's gone.
Then, yes, no doubt, these people may very well think about having a, but there cannot be a waiting list in view of the 2015 Act. Isn't it 15?
Yes, 15.
15 or 5? 5.
No, 5, sorry.
5.
Yeah.
Isn't it, Mr. Nath, that there cannot be a waiting list now? So you have to only take those who have been selected. Because the concept is, if they are not, it is out. You have to go for a fresh
Fresh
selection.
election, yes.
The concept is foreign waiting list.
Number of candidates only, selection is two.
That is it. That is the law. AFRBM. We have missed the presence of Mr. Arbor Pujari, who is ardent supporter of AFRBM. No case. Chalo. Heard, Mr. Name.
PK Munir.
PK Munir. The learned counsel appearing on behalf of the petitioner. Mr.
I am for respondent number 2 and 3, my lord.
Mr. T.R. Gogoi appears on behalf of the respondent number 1. Mr. H.K. Das appears on behalf of the respondent number 2 and 3. And Mr. B.K. Bhagavati appears for respondent number 4. The petitioner herein have assailed the appointment till the selection and the appointment of
Respondent number 4.
selection of the respondent number 4 as well as the subsequent appointment. Appointment has been done.
Done. Yes.
As well selection as well as the subsequent appointment of the respondent number 4 in the instant proceedings. And have challenged the selection of the respondent number 4, which is the notification dated 9/8/2023, and the subsequent orders passed in pursuance thereto in favor of the respondent number 4 being appointed. Full stop. For deciding the for the purpose of deciding as regards for the the petitioner herein has approached this court by challenging the appointment of by the selection of the respondent number 4 on the basis of the notification and then the selection which was notified by the notification dated 9/8/2023 and the subsequent appointment made on the basis thereof. Full stop. The case of the petitioner herein is that an advertisement was issued on 10/3/2023 by the District and Session Judge, Kamrup Metro, that is the respondent number 2 herein, calling for inviting applications from eligible candidates for the various posts, including the post of peon, including 3 posts of peon, which were specifically reserved for ST bracket P, comma, ST bracket H and PWD. Full stop. The petitioner herein had applied as a candidate under the PWD category. It is the case of the petitioner that the respondent number 4 had applied in the category of STP. STP or STH?
STP,
Huh?
planes.
STP, as would be evident from the acceptance of the application
The evidence
issued
on
by the district and session by the respondent number 2, wherein at serial number 6 of Annexure 1, Roman 1, of the notification dated 26/6/2023, the respondent number 4 was shown in the category of ST bracket P. The learned counsel further refers to the acceptance of the candidates in respect to the PWD category, wherein the petitioner's name appears at serial number 166 in the category of PWD. The learned counsel further submitted that pursuant thereto, a selection was conducted, and as would appear from the stand which have been taken by the respondent authorities, the respondent number 4 had submitted an application for non-consideration in the category of PWD, and on the basis thereof, the notification dated 9/8/2000, on the basis thereof, the respondent number 4 was selected in the category of PWD, although she applied in the category of STP.
No, actually applied in the category of PWD. But there was inadvertent
And
mistake.
thereupon, the respondent number 4 was selected in the category of PWD. Full stop. He further submitted that the respondent authorities, more particularly the respondent number 2 as well as the respondent number 3, have deviated from the selection procedure and held a separate interview for the respondent number 4, which violates the mandate of Article 14 and 16 of the Constitution. Anything else? No. Per contra, Mr. H.K. Das, the learned counsel appearing on behalf of the respondent number 2 and 3, submitted that the respondent number 4 had duly is a candidate had duly applied in the PWD category, but due to oversight, in the acceptance list, it was shown as STP, full stop. Upon this aspect being brought to the attention of the court, attention of the respondent number 2, comma, the said aspect was remedied, and thereupon a selection was held wherein it was found that the respondent number 4 was the most eligible amongst the PWD candidates for which she was selected. See, Anna, she was selected, which was notified by the notification dated 9/8/2023, isn't it?
Yes.
Full stop. Mr. B.K. Bhagavati, appearing on behalf of the respondent number 4, submitted in the same lines as in the Mr. B.K. Bhagavati, the learned counsel, appearing on behalf of the respondent number 4, drew the attention of the certificate which was issued in favor of the disability certificate which have issued in favor of the respondent number 4. Respondent number 4, and further submitted that she duly applied in the category of PWD. Full stop. He therefore supported the submission so made by Mr. H.K. Das, the learned counsel, appearing on behalf of the respondent number 2 and 3. Full stop. This court have duly heard the learned counsels appearing on behalf of the parties and have also given an anxious consideration to the materials on record. Full stop. The fact that the respondent number 4 is eligible, in the fact that the respondent number 4 had applied in the PWD category is not in doubt. Full stop. The fact that the respondent number 4 is eligible to also apply in the PWD category is also not in doubt. Full stop. This course further takes note of that the respondent number 4 was found to be most eligible amongst the PWD candidates by the selection by the selection board. Full stop. Consequently, this court do not find this to be a fit case for has been found here. Full stop. Consequently, there is no violation of Article 14 and 16 of the Constitution insofar as the selection of the respondent number 4 and the subsequent appointment of the respondent number 4 as a peon. Consequently, this court finds no merit in the instant petition for which the instant petition stands dismissed. Interim order is there? No.
No.
That's all.
Deeply obliged. Deeply.
Item 4,
Lord, in this matter, the disciplinary authority, my lord, the inquiry officer submitted the report.
Ensure.
No, not now, my lord. I have already conveyed that, my lord. The inquiry officer submitted report. The disciplinary authority has considered the report and given a copy to the charged employee so that she can submit her reply as per Rule 9 procedure. And 1 week time has been given. If she submits her reply, then accordingly, disciplinary authority will take a decision in the matter in accordance with the view expressed by your lordship.
List this matter again on 12th of June.
12th of June.
You file your reply,
Yes,
whatever may be.
Yes.
Be generous also in your reply.
highly authorized. But
item 5,
Yeah, withdrawal of the petition.
there is some problem in this particular code. There is some problem in this particular code with amongst the employees, my lord. I have been conveyed that thing, my lord.
This needs to be unnecessary things if we do. it,
Yes,
have
my
a
lord.
problem. Yes, what has happened? Finance.
I'm told that all the councils are on legs in different court.
Kala, they have the presence of these people. Judicial Department, LR, and the Finance Department, Commissioner. be present in it. They are not there. Have they filed the affidavit?
Yes, yes,
What do they
they're
say?
doing the same thing. Well, if your lordship would see the affidavit filed by finance, page 48,
Page 48.
48, they have received the proposal and thereafter made certain queries. The queries are at page 48.
Oh, that affidavit is not there. Where is that affidavit?
It is filed on 15/5.
The affidavit I see here. And both the LR has also filed.
LRS said that they have these questions once they have received from finance, they have forwarded it to High Court.
Then,
Now,
yes, Mr. Das, who is appearing in this case? Who filed question? Who is appearing in this matter? M. Bhattacharjee, additional senior.
MS S. Sharma, I think.
Ms. Sharma, she is appearing on behalf of High Court Lordship.
He's saying that pursuant to the order passed by this court on 8/5/2025, affidavits have been filed on behalf of the finance department as well as the judicial department of the court. However, the same are not on record. First of list this matter again on 12th of June 2025. The registry shall bring on record such affidavits.
Deeply applied.
Supplementary item 16.
May it please your lordship. Lordship, they have filed that affidavit yesterday, lordship. But, your lordship, in all respect, it's an inadequate affidavit, lordship. There's no data regarding lordship, the 100% vacancy that was lordship had ordered the 23. 25.
My lord, may pay this paragraph 3, my lord.
And your father retired as?
16, my lord.
He expired on 16, my lord.
Why?
Lordship.
He expired in the year 2016.
Yes, Lordship.
At that time, you were 17 years old.
Lordship, there's some mistake. I think I'm 18 years old.
At that point of time.
18 years old.
So why did you apply after in 2023?
What happened is also immediately after my father's death, Lordship, in 2018, my mother applied actually, Lordship. She was healthy and well that time. She could apply. I was studying, Lordship. That's why she applied, Lordship.
Your mother applied not in 18, your mother applied in 2022.
No, Lordship.
You have stated page 50.
No.
First time she applied in the year 2018.
Yes, Lordship. That was rejected, Lordship, for want of vacancy, and it was in the order. It was given that as and when vacancy arises, you may apply again. That was given, Lordship. In 2022, Lordship, after this order was passed during COVID, Lordship, in 2020, Lordship. At that time, Lordship, there was no condition for me to
Then
either
your
challenge this
mother
or
again applied in 2022.
I applied in 22. That was not even considered also, Lordship.
Mother applied.
My mother applied. But in that application, I had I had stated that my daughter is also now eligible. Either me or my daughter, anyone may be considered for sake of justice, Lordship. Now that application is not even considered.
But you have to understand that compassionate appointment is not a matter of right.
I understand, my lord.
Then how do you claim your right?
My lord, I am not claiming my lord. I stated in my application how I am living at this stage. My lord, when I have filed the petition, I have stated in my paragraph how I am making my living now.
How?
Look, if I may, Lordship, through the paragraph.
How did you study? Your father expired when you were 18.
Lordship.
So at that point in time, you must have been doing your +2. 8 plus,
Lordship.
10 plus 2. Thereafter, how did you become, do your MBA and MA?
Lordship, I got my this one through Lordship. That I have not taken the instruction from the client, Lordship, but probably because I'm a meritorious student, Lordship, I got some concession also, Lordship, from the college authorities. I have to take instruction on that aspect, Lordship.
No, then how, if you could do that and get an MA, then, and how are you surviving all this while?
Lordship, on the family pension, what is there,
So,
Lordship, but
somebody is
Lordship,
getting a
the entire family is of 4 persons, Lordship. I have a sister, a brother.
How much family pension you are getting? Your mother is getting?
Family pension is of Lordship somewhere around Lordship 20,000, Lordship.
Oh, very good. No, right.
And about 17,000, Lordship, 879. And what I have stated in the petition also, Lordship, I am paying of the family pension, I have to pay back whatever loan I had taken from the outside, Lordship, for my father's treatment, Lordship. My mother is repaying them. So,
How?
Lordship,
Who paid? By cash.
Lordship, probably. Lordship.
Who paid? How much loan did you take?
Various debt instruction also. I have, Lordship. But
How much loan? Did he show it in his accounts? Because that day Supreme Court passed one judgment, na?
Yes, Lordship, I am aware of the judgment, Lordship, that 2 lakhs more than 2 lakhs is violation of Article.
Let us also refer that person's name out there. How did he pay so much cash? No case. And in more particularly in view of the recent judgment of the Supreme Court, what is that Debabrata Roy or something, na? What is the name of the judgment? Debabrata Roy or? Huh?
You are Lordship.
Huh? What is the name?
Debabrata Tiwari, West Bengal versus Debabrata.
Yes, after that, this compassionate appointment scheme is very.
But Lordship, there was a delay of almost around 18 or 20 years Lordship in that case, and
No, that is not the question of delay so much, but the guidelines which have been there.
it's Lordship, but
Paragraph 37. I think 36 to 40, up to 40.
Can't help you.
also, my Lord, the High
You
Court
are
has-
meritorious, then why don't you apply?
I have been applying Lordship, but
Apply.
but
This is for less meritorious people. Compassionate. Hello.
Lordship, the High Court has considered this
Ah.
application. The High Court had considered the application, but rejected on a wrong.
Wrong ground. But taking
Thereafter, I
into
immediately came before your
but
Lordship.
taking into account that one judgment has come up in respect to the principles which have been given in Mohinder Singh Gill. But when it affects public interest, the said principle cannot be applied. Mohinder Singh Gill or even Govardhan Judge Bhanji, 52 Supreme Court, page 16, says that public orders passed publicly should be supported by way or on the basis of the reasons assigned therein. But recently the Supreme Court said, yes, that would be true insofar as vis-a-vis this person's concern. But the right to compassionate appointment involves the right of others also, who may also have some right over that particular post. And more particularly when the government today, you see, at the end of the day, the government today does not have the posts, the manner in which it is to be done. Yes, those people who have died earlier, they can get a compassionate death. But how do you explain the delay? Means if you could survive all this while from 2016 onwards, till we are almost a decade, and you could do your MA in arts, and as you say, a meritorious student for which you got merit, then why should we keep these posts out there? No good.
Anything, Lordship, will not consider the period of COVID. That sort of even the Supreme Court is not considering that period for possible limitation. That period 20 to.
Did you stop eating then?
That's what Lordship, they had to somehow make 2 meals. They had to worry for that during that period, Lordship.
Everybody had. Everybody at that point of time. Nobody could get even proper rations. But at the end of the day, you were still receiving some amount, which many people didn't get at that point of time. Heard Mr. So-and-so, the learned counsel, appearing on behalf of the petitioner. Mr. G. Bush, the learned counsel, appears on behalf of the learned standing counsel, appears on behalf of the Guwahati High Court. appears on behalf of the respondent numbers 1, 2, and 3. The petitioner herein is aggrieved as regards the rejection of her application for being appointed on compassionate grounds by the communication dated 29/2023. And it is under such circumstances the present petition is being filed. Full stop. From the materials on record, it transpires that the father of the petitioner was working as a lower division assistant in the office of the Chief Judicial Magistrate Dhemaji. Full stop. He expired on 9/7/2016. After rendering 29 years of service. The petitioner at that relevant point of time was 17 years old. Full stop. The mother of the petitioner thereupon, on 12/10/2018, applied for being appointment on compassionate ground. But the said application was rejected on the ground that there was no vacant post of grade 3 and grade 4 in the establishment of the Chief Judicial Magistrate Dhemaji district. Subsequent thereto, again after the COVID period was over, the mother of the petitioner submitted another application on 28/4/2022 as a vacancy arose in the office of the Chief Judicial Magistrate Dhemaji in the post of grade 4. However, the said application was not at all considered. In the meantime, the petitioner completed her studies and obtained a Master in Arts degree in English from the Dibrugarh Hanuman Box Surajmal Kanoi College in the year 2021. She further had completed a 6 months diploma course in computer application with A grade from Computer Education Development Society, Dhemaji. She therefore being qualified for the post of the lower division assistant, which is a grade 3 post, submitted an application on 14/6/2023 seeking appointment to the post of LDA, which was likely to be vacant as per the information obtained under the Right to Information Act. The said application was rejected by an order dated 29/2023 on the ground of non-availability of vacant posts in the cadre of grade 3 and grade 4 in the establishment of the Chief Judicial Magistrate Dhemaji. And it is under such circumstances the present writ petition has been filed. The record reveals that upon filing of the writ petition, this court, by an order dated 15/5/2024, issued notice and passed an interim order to the effect that the respondent authority shall not fill up the vacancy till the next date of listing. Full stop. It is seen that subsequent thereto, an affidavit in opposition was filed by the respondent number 3, stating inter alia that vacancy of 3 grade 4 posts under the establishment of the respondent number 3 arose. And accordingly, the advertisement for filling up the 3 grade 4 posts of peon in grade 4 was published. And the recruitment process was completed and the candidates were duly appointed. In the month of April 2022. Subsequent thereto, the mother of the petitioner had submitted her application on 28/4/2022. Which was subsequent to the completion of the selection process. It was further mentioned that there was no vacancy in the grade 3 and grade 4 posts for which the applications were submitted by the petitioner was rejected by the order dated 29/2023. It was also mentioned that a post that those steps were taken for filling up a vacant post of Jarikarak, which was lying vacant from 8/9/2023, the same had not been filled up in view of the interim order passed on 15/9/2024. Full stop. Pursuant to the filing of the said affidavit in opposition, this court took up the matter on 23/2025. Wherein, taking into account the scheme for compassionate appointment for the Guwahati High Court principal seat and the district court establishments of Assam, dated 3/1/2017, this court inquired with the Standing Council of the Guwahati High Court as to why the impugned order dated 29/2023 was made on the basis of the establishment of the Chief Judicial Magistrate Dhemaji centric and not the post of lower division assistant (direct recruitment) or grade 4 direct recruitment, which are cadres mentioned in clause Roman 17 of the said scheme. In that regard, there was a direction also to file an affidavit. Pursuant thereto, as there was the matter was listed on 8/5/2025, when there was no affidavit being filed, but Mr. G. Boisher, the learned standing counsel, placed before this court that the scheme for compassionate appointment for the Guwahati High Court, principal seat and the district court establishments of Assam dated 3/1/2017 no longer was holding the field in view of a subsequent notification dated 19/4/2018. Taking into account the above, this court further directed that an affidavit be filed by the Registrar General, be filed by the Registry of the Principals of the Guwahati High Court, filed by the respondents, on the basis of the directions of passed on 23/2025 and 8/5/2025. It is seen that pursuant thereto, an additional affidavit was filed on 21/5/2025, wherein the entire vacancy position in the cadre of lower division assistant direct recruitment and grade 4 direct recruitment was placed as annexure R7. It has been mentioned that insofar as have been mentioned. Further to that, reference was also made to the scheme for compassionate family pension in lieu of compassionate appointment. Bracket. Compassionate Family Pension Scheme dated 14/9/2017. And it was mentioned that in terms with clause 5.11, the said scheme was only available to those persons who was only applicable in the case of those employees who die in harness on or after 1/4/2017. It was also mentioned that in respect to the office memorandum related to compassionate appointment would be applicable to those who died on or before 31/3/2017. Taking into account that the scheme for compassionate appointment dated 3/1/2017 was only discontinued by the notification dated 19/4/2018 on the basis of the notification issued on 14/9/2017, that is the compassionate family pension scheme, and the later scheme do not apply insofar as those persons who expired prior to 31/3/2017, it is apparent from the said additional affidavit that the scheme for compassionate appointment from the Guwahati High Court for the Guwahati High Court principal seat and the district court establishment of the Assams dated 3/1/2017 shall be duly applicable in the present case. First, in the backdrop of the above, this court have duly heard the learned counsels appearing on behalf of the parties and given an anxious consideration. First, it is seen that the father of the petitioner expired in the year 2016. First, at the present, as on date, when the petitioner, the instant application is being, as on date, when the writ petition is being taken up, comma, almost 9 years have passed by. Full stop. In the meantime, the petitioner who was just 17 years when her father expired, she thereupon completed not only diploma courses but has also obtained a master degree in arts with English honors. Full stop. This court further finds it relevant to take note of a judgment of the Supreme Court in the case of State of West Bengal versus Debabrata Tiwari and others reported in 2023 SCC Online SC 219, wherein the Supreme Court culled out the principles for making compassionate appointments. Paragraph 32 of the said judgment, paragraph 32 and 33, and 34 of the said judgment being relevant is reproduced hereunder. From a perusal of the above judgment, it is therefore clear that appointment on compassionate grounds is not a source of recruitment. And the reason for making such a benevolent scheme by the state or the public sector undertaking is to see that the dependents of the deceased are not deprived of the means of livelihood. First, it was further categorically observed that the grounds that appointments on compassionate basis are made in order to enable the family of the deceased to get over the sudden underline financial crisis which have resulted on account of the death of the sole bread earner. First, in the instant case, this court, taking into account the law as laid down by the Supreme Court, not find that a law laid down by the Supreme Court is of the opinion that this is not a fit case where any directions can be issued to the respondents for the consideration of the prayer of the petitioner for appointment on compassionate grounds in terms with the scheme for compassionate appointment for the Guwahati High Court, principal seat and district court establishment of Assam, dated 3/1/2017. Ito ko ba suti ko yun, ha? More particularly on the ground that there appears to be no basis in as much as the petitioner, along with her family, have been able to tide out from the financial crisis which resulted on account of the death of her father. Full stop. No doubt. It is mentioned in the petition, in the application, that various loans were taken. And as such, there is a requirement for grant of a compassionate appointment. And as such, for purpose of repaying the said loan, the application for compassionate appointment should be considered, comma. In the opinion of this court, the said under no circumstances can be a ground for the purpose of entertaining a claim for compassionate appointment. Under such circumstances, this court finds no merit in the instant petition, for which the instant petition stands dismissed.
Deeply, It's your lordship. Finances filed this affidavit.
You have filed the affidavit?
Yes, my lord. Yesterday we have filed it, my lord.
Where is that?
Well, from record. I have just got it today, this morning. It's not on record. If they want the final reply, or you will fix a date, my lord, for final consideration. Final consideration of the matter. Or you will fix a date for final consideration. In the meantime, they may submit a reply, my lord, to the affidavit.
You want to file reply?
My lord, there is a certain facts, yes, my lord.
It has been brought to the attention of this court that the finance department has filed an affidavit. Which the Mr. N. Burber, the learned counsel, submits that he would submit a reply. Taking into account the above, this matter on 12th June 2025. 12th June?
My lord, on 5th, if possible, 5th June.
No.
My lord, then late, subsequently, that week I will not.
19th of June?
My lord, on 17th, if possible, my lord, 17th, Tuesday, that would be a Tuesday as well. And 27th, my lord, 27th.
Will be available on Thursday only.
26th.
26th, my lord.
26th of June 2025. In the meantime, the petitioner would be at liberty to file the reply on or before 23rd of June 2025. First of the registry shall bring on record both the affidavits. Shall bring on record the subsequent the pleadings.
For orders, item 7.
But this case was filed on one point, you know, it was a waiting list published while selecting a post of peon. You know. And in that waiting list, I was at the number 1. But subsequently, there another vacancy came in.
Yes, Mr. Gogoi.
Buddha.
Finance. Where is the concept of waiting list? As per the AFRBM Act. What is this concept of a waiting list?
Well, in pilot 7. There is no concept of minus waiting list, madam. Section 7, madam, very clear. Number of posts, number of minor elected candidates. Section 7, madam.
But there is the ministerial rules, my lord, the Assam District and Session Judge Establishment Ministerial Service Rule 1987. Here, my lord, in these rules, my lord, in recruitment rules, it says, my lord, that for the whole year, vacancy should be declared, tentative vacancy should be declared, and the list should be prepared at the beginning of the year. And subsequently, the appointment can be made from that waiting list. So my claim basically on this. But the reply filed by the Guwahati High Court, it says, not High Court, it's by the district and session judge. It says that this rule is not applicable in case of peon. It is applicable in case of the lower divisional assistant.
It will not.
Let us see the AFRBM Act. When did the post fall vacant? You're referring
Yes,
to?
yes. Pardon me.
2022, my lord, what is it?
Hmm?
2022, Annexure 1. But in fact, the issue involved herein is a little bit different. My lord, actually, he failed to clear the test. There was a waiting list. And he now say that all the subsequent vacancies on that particular year has to be filled up by that waiting list.
No, I want to see the AFRBM.
Yes,
We
yes,
need
sir.
to make it clear. Because in the earlier matter also I saw that. Concept of, because I think the AFRBM Act takes
Down.
into consideration the notwithstanding anything. What has happened to these new rules? New rules?
We have already communicated. I think it is in the process of finalization and updated instruction, my lord. I am also yet to get actually when the date.
As the, in the new draft rules, have they put this aspect no waiting list?
After the AFRBM Act, in a set of.
No. If
I
you
don't
make a
remember,
subsequent law,
Yes, if it is incorporated,
then again the problem will arise.
In so far as I remember, my lord, I go through, there was no such thing like waiting list in the new draft.
No, first of all, the waiting list, if they were for 2 posts, and those posts have been vacant,
Yeah, that goes.
then there has to be fresh selection.
Yes, the validity of lab, in fact, Supreme Court judgment, I think it's there in the record. 97, 8 SCC 488, para 15. Is it there, my lord? क्यों खुला ना होगा?
And what is this IA business?
It will-
IA? IA for
It's
what?
for an interim order, my lord. Now, I believe after if the lordship closes the reputation, it will also close.
Full sir? Video, photo, income sabo position. Data.
Yes, this is it. In fact, that day also I passed a judgment somewhere on this waiting list. Maybe
This is A for section 7.
Section क्या है?
Section 7.
Gazette कौन सा है? Measures to ensure fiscal discipline. Huh?
no, waiting is taken and waiting is procedure.
Notwithstanding any other provisions contained.
B, my lord,
In- huh?
7B.
7G.
B, lordship is
Any
reading.
other, no new post shall be created in any department of the state or in autonomous so and so which are under the here without the prior concurrence. Now, this is okay.
G, my lord, notwithstanding.
No appointment shall be made by here or any
Fresh
authority
appointment to
under
vacant
it
sanction
in a
post
post in
shall be
anticipation of it falling due
The
in
select
month.
list prepared for a fresh appointment to vacant sanction post.
So there is
shall be
something
executed
categorically.
number of
The
vacancies.
7G, my lord.
G.
It's very
That
clear.
is what.
The select list prepared for the fresh appointment to vacant sanction post shall contain names equal to the number of vacant posts
Notified
notified at the time of calling for applications for filling up of the post.
It is a
So it's
non-obstantive clause.
it's implied.
It is a non-obstantive clause. It will override this rules.
Overriding.
Look. Heard Mr. A. Samwad, the learned counsel appearing on behalf of the petitioner. Mr. H.K. Das, who appears on behalf of the respondent numbers
4, I think.
2, 3, and 4.
2, 3, 4, yes.
And Mr. B. Gogoi appears on behalf of the respondent number 1. Full stop. The present petition has been filed by the petitioner seeking a mandamus directing the respondent authorities, more particularly the respondent number 4, to appoint the petitioner in the post of office peon, which had fallen vacant due to the promotion of Sri Nizam Hussain and Miss Suman Kumari to the post of LDA. And further, seeking a writ in the nature of certiorari for setting aside the communication dated 9/2/2023. Full stop. The case of the petitioner, as would be seen from the materials on record, is that the District and Session Judge Dhubri had issued an advertisement on 18/2/2022 in the establishment 18/2/2022 for filling up of 2 posts of office peon. Full stop. The petitioner participated in the said selection process and by an order dated by the select list dated 15/3/2022, 2 persons were selected to the post of the office peon, and the petitioner along with 3 others were put in the waiting list. It was further mentioned that the said waiting list shall be valid for 1 year from the date of the said list. Subsequent thereto, one Sri Nizam Hussain and Miss Suman Kumari, who were holding the post of peon, office peon, were promoted to the post of LDA on the basis of a selection made on 18/1/2000, on the basis of a select list prepared on 18/1/2023. And under such circumstances, the petitioner submitted a representation on the ground that against these two posts, the petitioner be appointed, as the petitioner was in the waiting list. Of the select list dated 15/3/2022. The said application was rejected by the communication dated 9/2/2023, stating inter alia that the waiting list was made in the select list, comma, in case the selected candidate for appointment does not join. But the said candidate having joined the establishment, comma, the petitioner's application cannot be considered. It is under such circumstances the petitioner has approached this court seeking the reliefs as already above mentioned. It is seen from the records that the respondent number, who is the district judge? What is the respondent number? That the respondent number 4 had filed an affidavit in opposition, thereby supporting the stand which have been mentioned in the communication dated, impugned communication dated 9/2/2023, 9/2/2023. In the backdrop of the above, this court heard the learned counsels appearing on behalf of the petitioner as well as the respondents. Mr. A. Samua, the learned counsel, appearing on behalf of the petitioner, drew the attention of this court to the Assam District and Session Judges Establishment Ministerial Service Rules 1987, and more particularly to clause to Rule 6, 5, and more particularly to the note appended to Rule 6(5) of the said rules of 1987. Agote rules of 1987 ko iribo, huh? For short, the rules of the rules of 1987. The learned counsel appearing on behalf of the petitioner therefore submitted that for filling up of the post in the cadre of lower division assistants, there is a requirement that the district and session judge shall call for application to fill up temporary vacancies of any kind of post which are likely to occur in the course of the year in the respective establishment. He therefore submitted that as the subsequent posts arose in the same year, comma, the said the petitioner who was in the waiting list ought to have been appointed against the vacancy which arose upon the promotion of Mr. Nizam Hussain and Srimati Kumari, Suman Kumari, isn't it? He submitted further that the said waiting list would be valid for 1 year. Per contra, Mr. H.K. Das, the learned counsel, submitted that the waiting list is being prepared for the purpose of accommodating for the purpose of allowing the waitlisted candidate to join if the selected candidates opts out after due selection. Full stop. He therefore submitted that with the selected candidates having already joined their post, the waiting list, the select list dated 5/3/2022 stands exhausted. Full stop. Mr. B. Gugoi, the learned counsel appearing on behalf of the respondent number 1 submitted that the concept of waiting list can no longer stand to exist in view of the Assam Fiscal Responsibility and Budget and Management Act 2005, and more particularly Section 7 1G, which mandates that notwithstanding any other provisions contained in any act or rules, the select list prepared for the fresh appointments to vacant sanctioned posts shall contain names equal to the number of vacant posts notified at the time of calling for applications for filling up of the posts. He therefore submitted that by virtue of Section 7(1)(g), the provisions contained in the note appended to Rule 6(5) can no longer, for preparation of a waiting list, no longer can exist, no longer would be permissible, as the provisions of the Act of 2005 overrides the said provision. Isn't it? Yes. I've heard the learned counsels appearing on behalf of the parties and have given an anxious consideration to the materials on record. Full stop. From the materials on record, it is seen that the advertisement so made was only in respect to 2 posts of office peon, while the advertisement dated 18/2/2022 pursuant thereto, a selection selection was carried out, whereupon a select list was published on 5/3/2022. Full stop. In the said select list, Sri Bikas Kolita and Sri Dilip Kumar Borman were mentioned as selected against the 2 of post of the office peon. Full stop. The petitioner along with 3 others were put in the waiting list. Full stop. This court at this stage finds it relevant to take note of the judgment of the Supreme Court in the case of Surendra Singh and others versus the state of Punjab and another. It is an admitted fact that the said Bikas Kolita and Sri Dilip Kumar Borman have duly joined the post upon being selected and appointed. At this stage, this court finds it relevant to take note of the judgment of the Supreme Court in the case of Surinder Singh and others versus State of Punjab and others reported in 1997 8 SCC 488, wherein the Supreme Court specifically deals as to when a waitlisted candidate may have a right to be appointed against the post so advertised. Paragraph number 15 of the said judgment being relevant is reproduced herein under. In view of the said judgment, it is therefore apparent, in view of the said judgment, taking into consideration that the said Vikas Kolita and Sri Dilip Kumar Borman have already, upon being selected, selected and appointed, have already joined the post, the said wait list, in the opinion of where the said select list stood exhausted. This court now further finds it relevant to take note of the fact, take note of the issue as to whether, in view of the Act of 2005, can there be a question of preparation of a waiting list in the select list? Section 7(1)(g) of the Act of 2005 being relevant is reproduced herein under. 7(1)(d) তাৰপিছত G to দিব হা বাকি কেইটা নালাগে A ওপৰত দি dot তাৰপিছত G to দিব. From a perusal of the above provision, it is therefore clear that the said clause, the said above quoted provision, it is therefore clear that the said provision has a non-obstinate clause, making it clear that the said provision shall override any act or rules and further mandates that the select list prepared for the fresh appointments to vacant sanctioned posts shall contain names equal to the number of vacant posts notified at the time of calling for applications for the post, filling up posts. Under such circumstances, by virtue of the rules of 1987, in that view of the matter, though the rules of 1987 permits preparation of a waiting list, but as the Act of 2005 overrides any act or any rules, it is not permissible with effect from coming into effect, with effect from the date on which the Act of 2005 had come into Act of 2005 had come into operation, that is from 17/5/2005, that a wait list, that a select list would contain names beyond the number of posts advertised. Consequently, therefore, this court finds no merit in the instant case for which the instant writ petition stands dismissed. I stands closed.
Item 8.
Yes, Mr. H.K. Das, circulate this.
Yes.
Because there shall not be any further witness.
Yes, I'll ask the Registrar General, my lord. No, this is another again, case of waiting list, this one.
Right, same.
My lord, similarity, my senior will say, but here also the petitioner was in the waiting list.
Yes, Mr. Sharma, what do you want?
It is one of the petitioner, he has applied for a post of peon in the establishment of the district judge board.
In the what quota? In what quota?
Not quota.
Ah.
This year, has issued advertisement, which is my annexure 1 for two categories of posts. Two posts for regular peon, and that is by the page 18. The,
One is OBC, one is general.
yes, no, or a two posts for regular post and one for contractual. For
Ah.
regular post, the page pay band is 12,000 to 5,000, 52,000, and the for the contractual post only 15,000, not.
Okay, one is for office peon is unreserved.
Has applied for both contractual and regular post.
Okay, then
And the district has said they publish the list separately. For
Ah.
the regular post and the contractual post regularly, my lord.
Hmm.
It is page,
then
my lord. So thereafter the examination was held, my lord.
Hmm.
That he has appeared for the examination and therefore result was published. Two persons. That is
Annexure 6, page 32.
actually. Yeah, my lord.
Been selected in the order of merit for post appointment in the two regular post of office peon, 1 and 2. Following candidate for contractual OBC, done. Then you are general.
Pranjal Das and Govinda, they were appointed in regular posts. To that, we had no objection.
Hmm?
But in the contractual post, one Narayan Das was appointed
Hmm.
and Gautam Das was kept in there. But in fact, they have not applied for a contractual post, madam. The Narayan Das and the Gautam Das, they have not applied for a contractual post. They
Okay.
have applied for a regular post. But my petitioner, he has applied for both contractual and regular. The person who has not applied for contractual post has been appointed in the contractual Narayan Das. And Gautam Das, he was kept in the waiting list. And after him, my petitioner was kept in the waiting list, my lord.
Hmm.
So the person who has not applied for a contractual post has applied. In fact, the two separate lists were published in the advertisement, two pay scale were shown. The person against which the application is made should be appointed in that post, my lord. So had they been not appointed in the contractual post, I would have been appointed, my lord.
Hmm.
The Narayan Das and Gautam Das, they're shown above me from the regular list. So if they are not appointed, then I have got the appointment in the contractual post, my lord. That is my case.
So you have no problem against Pranjal Oza and Govindo Das.
No problem.
Now question is of Narayan Das
I
and Gautam Das.
Gautam Das.
They have not applied.
Applied for contractual post. They have applied for a regular post.
Let us see the advertisement as to whether they are required.
Annexure 1, my lord. Annexure 1, page 15, my lord.
Hmm. Yes, Mr. Das.
Look, it was two eligibility. The advertisement nowhere said that separate application has to be given, but all the maximum of the candidate, they submitted separate application for both the posts. So as a matter of convenience, so that nobody left out, two eligibility list was prepared, but one selection held and one merit list. There was no separate selection for both the posts. So in that view of the matter, Milo, there was no illegality in selection. Apart from that, he being in the waiting list. In fact, in the impugn order that has been annexed in the writ petition, page 37, Milo, the learned district and session judge has indicated this aspect of the matter.
Page?
Page 37, my lord. Despite that, my lord, this writ petition has come.
37.
Yes, my lord. It was communicated to him.
I'm not satisfied with this reply, so I find it.
And selected candidates got the selection on the basis of merit.
Now, Mr., you applied for both?
Just for both contractual and regular.
Now, were you therefore given different dates for appointment, different interview process was there for you?
Interview process, I have called for interview, I have appeared for the interview.
No, well, because you were given two roll numbers.
Yes.
Now, where you have, whether there were two distinct interview process or one interview process?
Yeah, interview process is one, but they have submitted two separate this, my lord.
No, I'm not on that.
No,
You separate, you filed two applications.
Yeah.
When you filed two applications, you were given two roll numbers. Now, when you were given two roll numbers, whether there was a separate interview assessment? No. So one only.
Same examination. But least they have published for separately candidate for regular post and candidate for contractual post, my lord. That is in page.
And the contractual period is for what, how long? Yes, Mr. Das,
No, there is
where, who has been appointed in here?
this.
Who's the respondent? You are there. Show me your appointment letter. What is the period of appointment? Huh? Mr. Das, what is this? When you are having a contractual appointment, there has to be a period.
It has to be within 11 months thing.
Where is it?
Don't mention here.
The advertisement also there is.
But 11 months, if it's contractual, then 11 months, again, there will be agreement, those things will be there.
Where is it?
It may not be there in the appointment
No,
order,
in the
but
order of appointment, there has to be there.
yes, but they'll.
Where is it in here? Tomorrow he is going to ask.
No, even if it's not, I
Because
understand.
here
Mr.
in the
Lordship.
election, in the advertisement, there is no mention.
Yes.
What is the period of the contractual appointment?
Yes, but if it's contractual, it is implied that after 11 months, there has to be a fresh agreement.
How? From thin air.
It should be mentioned.
No, it is nowhere mentioned,
But
but
this type of appointments, you are giving him absolute rights. What is this
I'll check
contractual
up, my
business?
lord. I'll check up with the district. judge.
This cannot happen like that.
No, what procedure they have followed after the appointment?
Because if you are
that will have
having,
hearing.
because whatever may be, you have to, if it's a contractual appointment for a particular period.
Yes,
Now, if you are having a selection process for that, very well.
yes,
There's no quarrel with that. You may have a selection process, have it,
yes.
but the contractual appointment has to be limited to a particular period. What
Yes.
else is doing? I think we have to set aside this for that reason only.
No, that.
No, we have to set aside that because otherwise rights will accrue upon him.
No, I'll check up, my lord. I'll check because that.
Mr.
it is
Counsel,
question-
why it is necessary for future? The future is because tomorrow he is going to claim right.
No, he cannot claim any right being a contractual, my lord. He
Till
is
when?
not casual.
Not till when?
He is contractual.
Till when? Tell me,
That
the
thing, my lord,
advertisement does not say so.
Yes.
So can you remove him? Tell me,
Yes, my lord.
how?
No, there has to be an agreement. When there is contractual,
There's an agreement with you.
there has to be an agreement. I'll just check up.
I have to take instruction regarding agreement.
Will,
I have no instruction, my lord, but he joined on 6th, my lord. Regarding agreement, my lord, agreement part.
he'll be guided by that, the conditions of that agreement. I'll get the
Does the
instruction.
order of appointment say so? No.
No, ordered, order of when doesn't
What
say.
is this agreement business? You are giving him a full appointment out there
Lordship will
at a
kindly,
lesser salary.
I'll,
You are entitled to more salary. You are giving him a more post, important post. What is this contractual business? Giving him 15,000,
it's a fixed pay.
fixed pay.
Perhaps there is no sanction from the government for, regular fill up or something like that. Because
if you
this
want
question
to
was
have
not
it,
there.
You can very well have this, but it has to be for a period.
Exactly.
Your advertisement is not there.
It has to be for a period, my lord. I'll just,
In fact, it should have also been mentioned in this order.
it is
that-
for 11 months, subject to.
Not only 11 months. It should also say that subject to the sanction. That tomorrow if the financial sanction is not there, how do you pay?
No, it's true, my lord.
Then should we come up like that matter?
No,
The
exactly,
item number 1.
exactly.
Then
It doesn't contain the detail, but I'll just verify that with the, but so far as the present case is concerned,
present case only is the concern. This court will set aside this.
my lordship will give me one opportunity, I'll clarify this issue before.
And
the
if you are extending it,
Clear in the order.
this happened in 2023. How are you extending it?
lordship. No instruction, my lord.
No, how are you extending it? You cannot extend. Can you extend? It will the amount of permanency.
No, if there is an agreement, my lord, he'll be guided by the, he'll be, my lord, regulated by the conditions incorporated in the agreement.
Understood, but that is the subject to financial sanction.
Yes,
The sanction is only for the post of a office peon,
yes,
contractual.
yes.
For that, a particular amount will be given.
Head of account, major head, 2014, minor head, so-and-so, detail head, so-and-so, sub-detail head, 99.
Okay.
Expenditure.
So this expenditure will be given only for that.
Yes,
And therefore, how are you going to have it? How do you grant him an extension? Means you feel like you give
no,
him
there
an
has to be,
extension.
there has to be extension from the government, then only we cannot do on our own. So that has to be there.
Now, if you go for an office point contractual, very well you go ahead. But you have to put the period. You have not.
No, I'll
He has
just,
got his money for 11 months.
oh, sorry,
Very well, happy
Sorry.
he should be.
no, lordship will kindly appreciate, my lord. I'll.
And here submit their applications. Kindly see annexure 1, page 15.
Yes,
Why the word plural is being used? Why on earth you have given him two roll numbers?
lordship is referring to, submit their,
Applications.
intending candidate shall submit their application. It refers to candidates, my lord.
So why you have giving him two roll numbers?
My lord, our stand in the affidavit is that although there was no direction that in the lower, my lord, columns, paragraphs, lordship will not find any direction saying that the candidates has to apply separately for both the posts.
Then why have you could have given him only one roll number?
No, what happened, my lord? Maximum of the candidates submitted 2 applications. for
Obviously,
2
that
posts.
is what it is because you are having different posts.
Yes, my lord. So what happened, my lord? For the purpose of convenience only, eligibility list was prepared too. There was no separate, my lord, merit assessment was not separate. Even if this.
Because what happens, there is a difference. There is a time period fixed within which you have to file that application. If a person does not file the application within that time period,
On or before 31. Yes.
So tomorrow, did you, at the time of formalizing this advertisement or subsequently, immediately thereafter, did you take into account any aspect that we are going to accept one application, two application? Have you mentioned? How do you take a decision later on that we are taking out here for one application will be enough for both? How do you do it?
The decision that was taken is that
Now tomorrow, let us take it for the case of not office peon, jari karok. A
yes,
person files one application, would it be enough?
for Jari Karok.
An office peon?
No, application has to be there. I am not on that.
No,
Milord.
no, one application for both posts. Are you going to do that?
No. That cannot be, Milord.
This is same.
No, me.
Yes.
No, application has to be there.
Application is there. So I'm saying he
Huh.
files an application. Let us take the example of a jari karok and an office peon.
Yes.
So would you be accepting only one application for both? You are on the question of nomenclature of that.
Yes.
Tomorrow, I'm therefore saying that this office peon is one and one is jari karok.
Office here, it is office peon regular, office peon contractual.
There might be difference. Why have you done one?
Why, Milord?
One application, why?
This private respondent, he also applied. It's the case of
Understood.
the petitioner.
But if he had applied for both, you should have asked them to apply for say separately, or you should have said that, okay, you have applied for both very well. Then why did you give him two roll numbers?
No, this application thing is only for
Therefore, you are conceiving two applications.
we did not conceive two application. It came, it happened.
Then
in the
why
system.
have you given him two roll numbers? You could have given him only one roll number.
Yes, fine. Even if two roll numbers have been given, assuming, Milord, two roll numbers have been given, but where is the illegality, Milord? Petitioner has
No.
to show some illegality.
No, not the illegality. The question is, the last date for filing is on that date.
31. Yes.
There. So you are permitting somebody's application which was not there to be brought within the fold by taking this decision subsequently.
I don't think so, Milord.
Yes.
In the eligibility list, the private respondent's name is also there. When we publish the eligibility list, the name of the respondent number 4, it was there. He applied.
Where?
Page 18.
Applied for regular post, not contractual.
Whatever may be. See, it was a one selection for the both the posts. Page 18, serial number 22. Narayan Das.
And in the contractual?
Regular.
No, contractual he did not apply.
There. Why have you
One
given
selection.
him? Why have you given him?
One selection, my lord.
No, there cannot be one selection. That is why I'm saying.
No, it's one selection.
No,
It's
no,
a
no, no,
categorical
no.
stand.
No.
Petitioner is also saying without one selection.
No, that means as on that date, when you publish the list of candidates for the post of office peon contractual, you did not contain that he is a person who had filed an application. This happened subsequently. We have to set aside this appointment. Go for
What
a fresh
happened?
one.
Milord, I'm extremely sorry, my lord.
Be
Page
sorry.
28, page 20.
Remaining sorry is for division bench.
Milord, page 28 is the written test for office peon. It's a singular,
Mr. Counsel, first of all, why these respondents' names are not there at page 26 and 27?
26.
Are their names are there? Page 26 and 27? What is the name? Respondent? Your name?
Narayan.
Not there. Then,
And
meaning thereby, till then, you did not bring him within the ambit. Subsequently, your district judge must have thought, oh, no, we have to give him for good reasons.
Subject to correction, my lord, that that never happened.
Obviously, then why didn't you put him his name here?
I'll explain, my lord. My lord, the respondent number 4, two posts, maximum of the candidates submitted 2 applications. The respondent number 4, he submitted application for regular, beyond regular. We hold a single selection process. Single.
Then why did you make him contractual?
That is
He
what
did not apply that, means.
I understand that he did not apply this, all right.
Then,
But there was no
but your stand is different. Your stand is different. In your affidavit, your stand is completely different. Your stand is, there is no requirement. So when he has duly applied for one, we can give it for other also. Where is it?
That is what it was conceived that since we.
No,
we
this is
conducted-
highly illegal.
Well,
We set aside
since-
this.
Look, it was on the basis of merit,
Merit.
written examination.
No
and
merit,
interview.
no merit.
It was
no
on the basis of merit, my lord. And it is an admitted position on the part of the petitioner also that only one selection was held. Whoever is, my lord, applied for whatever post, one second. Whoever is applied for whatever post, it's contractual or regular, the eligibility list was for the purpose of convenience. One selection was held, all were called upon. My lord, interview marks and my lord, written examination marks were added and a merit list was prepared. In that merit list, my lord, the meritorious person got.
Division bench will help you out. Leho.
No,
I am
that is.
going to- Yes, what do you have to
Page
say?
30
30 and 31, my lord, call letters.
I've seen it. That is why I'm
At the
saying.
Same
These
day,
call
same
letters
time.
happen subsequently, after the last date. And when you prepared this list of candidates, which you have prepared, their names were not there. Why did you bring him? And more particularly, the reason why main reason is, what is this?
Your lordship is saying if the person has not applied, why you have given
Not
it?
only that, what is this type of orders being passed? How is the appointment
Look,
like this?
I can
Contractual,
clarify this, my lord.
not necessary.
I'm
This is to
getting
be set
instruct-
aside. Okay, clarify by 2, 2
next,
o'clock.
next.
3 o'clock. We have heard too much. It can't go beyond that.
All right, my lord.
3
I'll-
o'clock, only to that effect.
Yes,
To that effect, because I am concerned with this, what we have done.
I know, my lord.
This is a serious infraction being done by the district and session judge, whoever it is.
Whether there was
These
period
people
of.
should be more careful. When you are having a contract, first of all, in the advertisement, there is no mention. What is the period of the contractual? Tomorrow, in the order of appointment, there is no mention. Tomorrow he is going to say that, how do you remove me? Tell me. And it
Subject
does
to-
not also, the
subject to-
order of appointment also do not correlate to some agreement also.
Exactly.
Then,
District judge will be saved if there is an agreement.
no,
Otherwise-
then also you cannot.
Perhaps then we can take some.
This is gross illegality which the district judge have done.
I'll just-
Sorry to say, this
I'll-
type of actions are not envisaged from this court.
I'll appraise your lordship what they have
We have
done.
to set aside this appointment, go for a fresh appointment, whatever may be, if you want for, or
But so
you-
far as this.
or adopt a pick and choose, which you have done.
No, we can choose. There is.
This
Written-
contractual, Mr. Das, these contractual appointees are mostly pick and choose. Here you have done it to show it more fair, but in doing so, you have made it more unfair.
Item 9,
I have my reservations with regard to the submission made by the petitioner that even if he has not applied, how can you call and, but I have, because had it been 2 selection, fine, yes. If he has not applied, how can you select it? He is not at all a candidate for that particular post. But one selection has been held, he has been.
That is also wrong.
No, I understand. It is only with regard to participation.
3 o'clock, we passed that order. Only saving grace is that you may get some instructions so that I can put it out here, which may help you in going into the division bench. Nothing more. I'm passing an order allowing you. Only, however, only setting aside his. Yes, Mr. Song, what is
My lord,
this?
here it is a case for overqualification.
Huh?
I am HSLC passed and it is.
Driver?
No,
Which-
peon.
Peon,
But I'm still
overqualified.
working there, my lord.
So
I'm
what?
working in a contingent, as a contingent worker there,
Hmm.
on contractual basis. I'm
Hmm.
working there since, 2015.
I
And
passed many orders out here, na?
Yes,
Yes. Should not pass. Are you challenging the advertisement
yes, my lord.
after joining?
No. Selection yet not taken place. My, application is rejected. And the selection has not yet been done.
Why there's a stay?
No, there is not a stay.
Then how, why the selection has not happened?
Because this honorable court has issued notice and, subject to the outcome it was made. That is why perhaps.
Yes, why the selection has not happened?
I don't have instructions like this, my lord.
Yeah.
The selection is not done. To my instruction, selection is not.
I'll get the instruction, my lord, but this should not stop.
Ah,
Because
this
there was
should
no
not
interim
stop.
order.
Have it, we issue rule and we have this after 10 years?
No, my lord, if lordship.
No
wishes,
case.
There is a Supreme Court judgment, my lord, which says.
Go to Supreme Court. I can't help it. Because if we don't care to these people, otherwise no person will get. We'll have it in 2035. Limiting of the zone to those possessing the minimum qualification, legality, recruitment of to the post of the peons in the district of where relevant rules prescribing the passing name on grade 4 in the regional languages because in view of the large number of applicants as compared to the number of vacancies. When man in apprehending the applicant policy and might not take proper. Thank you. So you want to have an MA?
It's not that like that.
No, if we don't have anything, an MA will apply for a post of peon. He will be proficient in English.
The same time with this.
So I wish to
With all
say
due
these
respect to
people.
Your lordships, what has been fallen from the lordship. Then, my lord, we have to restrict our child that don't go for further studies. You have to work as a peon.
Would you like him to be a peon?
That is what I'm saying.
You want them? Would you like your son
Hello?
to be? I'm just saying, would you like your son to be a lawyer?
Supreme Court says, that is what Honorable Supreme Court says, that you can give a minimum qualification, but you cannot restrict to the maximum. If lordship can come to paragraph 2021-18 of that judgment.
Kuntu, resolve.
Result.
Thereafter,
Which
latest
has the
judgment is
effect
there
of denying
2021,
a
my lord.
I don't know that.
Anit Kumar Das.
I do not know that whether this judgment is holding the field or not, or if it is set aside, I don't know. If it is
Huh?
overridden.
This-
This judgment is overridden or not, I do not know.
No, Rizaul Usman Ghani was considered in Milord Anit Kumar Das, 2021 12 SCC.
Because you
Held
see,
against,
on the administrative side, I also have this thing. But there is a full court resolution on the basis of which I can't.
And next thing, your lordship, my lord, will consider my annexes 10 onwards. There is no consistencies in the advertisements issued by the district judicial authorities. my lord.
Anit Kumar Das.
ভালকে নকৰা, petition টো কওক।
No, Robo, মই চাই আছো। মই কপিটো তাতে দি দিলো।
অনিত কুমাৰ দাস, অনিত।
ANIT. 2021 12 SCC, page 80.
মানে ওসমান গনি টার্ন ডাউন নাকি কনসিডার করছে রেফার করছে একুশ বারো আশি 2021 2021 12 SCC page it. SCC was 2021 12
is confined to the file. Para 21 of Dismissal.
12 page 3
Para 21.
These are three judges.
Yes, and para 21 of Rizal, which my friend is relying, it clearly says this should not be of universal application. Rizal is in the peculiar facts of that particular case.
Now here, they have referred to the judgment of Jarur Ahmad,
Jarur Ahmed Rathar, that, yes, that is the latest one.
that is 2019 to SCC.
Yes, my lord.
And paragraph 26
I have gone through
out
this,
there.
my lord. It considered all the previous judgment, Jarur Ahmed Rathar. Jahur Ahmed Rathar, sorry.
Here say, we are in respectful agreement with the interpretation which have been placed in the judgment of Jyoti KK in the subsequent decision in Nanita. Here it says the prescription of qualification of a post is a matter of recruitment policy. The state as the employer is entitled to prescribe the qualification as a condition of eligibility. It is no part of the role or function of judicial review to expand upon the ambit of the prescribed qualification. Similarly, equivalence of a qualification is not a matter which can be determined in exercise of the power of judicial review. Whether a particular qualification should or should not be regarded as equivalent is a matter of the state as the recruitant to determine. So and so turned on a specific statutory rule upon holding that the higher qualification would presuppose the acquisition of lower qualification. The absence of such a rule in the present case makes a crucial difference to the year. In that view, the division bench was justified in reversing the judgment of the learned single judge and coming to the conclusion that the appellant did not meet the prescribed, and we find no error. And again, it is the employer to determine 17.3.
Yes, ma'am.
Yes, Mr. Samoa. Were you
But,
not aware of this decision?
No, the decision I was not aware. I'm just now.
But Mr. Samoa, don't make submissions before this court on the basis of untested judgments.
No, my lord, this is the judgments, my lord.
This matter, the matter has come up after a long time. You must be aware by then. 24,
My lord,
2024.
After the,
After 1 year also, you have not read it.
after the
Be
break, my
very
lord,
careful.
after the break, my lord, the lordship take up.
Obviously, case for dismissal. But we expect Mr. Samoa to be more careful when you submit judgments. We don't expect that you tomorrow.
This judgment is not overruled, my lord. This judgment.
Not necessary. This is the law of a three judges bench of 2021. After 21 years, the judgment has been cast. There are in the meantime 2019 two SSC is there. I would have understood you may not have looked into this judgment, that there are many other judgments. You have to be very careful when you place judgments before this court. Anyway, 2 o'clock. Let us dismiss this matter again.
I have,
Right, affidavit in opposition file.
yes, my lord, I on behalf of the respondent number two, affidavit in position file, my lord. My lord, I may be allowed be allowed to correct only one word, my lord. There is a typing mistake, my lord. How to by hand or I'll by
Where?
para number 5, my lord. Para number 5, page 92. Page 92, para number 5. That's
There's
my
no
lord.
page 92.
Page 92. Para number 5, last but one para, one line.
Hmm.
That also is, my lord, that is wrongly typed and with not, that is without, my lord. Only outward I have to put, my lord. Without, that is with, outward does not mean there, man. Only I want to put out only. Is without, the outward is missing, my lord. So I may be allowed to correct it either I file a application or, my lord, I by hand, my lord.
Yes.
My lord, in fact, the application which had been submitted to us, here it is page 180 to 188. But in this application, it is 90 to 98. I don't know how.
That is,
They have, it starts from page 179 onwards and ends with page number 197.
my lord, I have. Oh, there is another affidavit in the meantime file, probably that was. That presentation I will be correct with, my lord, because the copy which was, my lord.
Yes, what is your submission?
My lord, we need some time to file reply because the Registrar Vigilance also filed an affidavit in opposition as well as the affidavit in opposition filed by the respondent number 4, that is the district and session judge.
It was filed on 14th of May.
Yes, my lord, we have received it on 15th and one has been received on 16th.
And what has happened to the present status of the inquiry?
Regarding the
The
inquiry that is probably against the petitioner. That is, my lord, that is going on in Arunachal, that is, he can be answered.
Yes, Mr. Patin, what has happened to the inquiry? Mr. Patin,
Inquiry is not yet completed and she has been directed to produce the defense witness in the inquiry,
defense witness
departmental inquiry,
in the defense.
defense witness. And the inquiry is made only because of her not joining to the duty. Yeah, in spite of revoking the release order.
Where is the original of this?
My lord.
Original of this affidavit. I only get because I'm here. You have filed this affidavit
No, Arunachal.
Arunachal. Then how do you correct it there?
For registry, I'll do it. For registry, I'll, because I deposit in the registry file it there.
Hmm?
For registry, my lord, I have to do it.
So here is without concurrence.
Without con.
So I'll record it in my order that this is corrected as without concurrence. The word with appearing in the fourth line, in the 1, 2, 3, 4, 5, 6, 7.
Fifth, last but one line.
That's but one line.
Without at is miss that is what is
With
unnecessary.
should be substituted by the words
Without.
without,
With is valid.
and the same is duly correct. Yes, Mr. Das.
Election of all.
Lot of affidavits has come.
Hmm.
This way, that way, all affidavit has come, 4 affidavits, my lord. My lord, we want just a reply, my lord, otherwise, I mean, if your lordship allows us, my lord, we have seen that sometimes we will be given the final reply.
Well,
If it is or not inconvenient.
we take it up next week. On 29th, you file your reply because you've got it on 15th. Huh?
My lord, if it is not inconvenient.
29th.
Not 29, any date whichever is convenient,
29th?
after that.
Why?
A bit of difficulty there.
Who's
It's not my difficulty.
number 2?
Oh, yes, that is there. That is there.
Number 2 does not apply.
If it is possible, I want to be before your lordship.
You have been before me in this matter everywhere I have traveled.
Even in, if your lordship would have been assigned a bench in Mizoram, then I would have gone there itself.
Now, Mizoram, they have proper, yeah, they can very well provide you on.
But no, I find that the video link of Arunachal Pradesh was finding it difficult. West Kohima was okay, fine. The link, we find that there is some difficulty in, here maybe there is some problem.
Anyways,
30th, oh, your lordship is taking on Thursday this bench, yes, right.
On
Kohima,
29th.
Tarpa Kohima.
you have it on
We'll do it,
paper.
we'll do some there, sir.
I'm for the respondent number 1 and we have already filed our affidavit also.
Yes, now you have no objection in the APHARC releasing, as I could see
Lordship.
from your affidavit.
I have seen their affidavit lordship. They said that approval of the government is required, but there's no like any rules or law lordship where we have to give the approval lordship. That's not correct statement from theirs.
But what I see in the affidavit, that's why my lord, that he wants a correction, because that's a word is issued with concurrence and approval, it should be without.
And that I have.
So for that, I'll give you time. For what? You have no business. What you have stated is absolutely wrong. The government has no business out there. Your only stand is that you cannot release the petitioner on the ground that you have to take the permission from the government. The government says that we have no business in that regard. Then
This has been made clear after the affidavit.
Huh?
After the affidavit has been filed, ma'am.
they have filed the affidavit.
Yes, ma'am.
Then,
It's a position.
then why you are not releasing the petitioner? Why?
My lord, just now we have come to know, after they have filed the.
Affidavit was filed long time back, 19th of May. Mr. T.J. Mohanto, appearing on behalf of the respondent number 2, submits that the affidavit in opposition has been filed. He however submits that in the said affidavit in opposition at paragraph number 5, more particularly in the sentence, inverted comma, however, it is stated that the release order in favor of the petitioner dated 18/9/2024, bracket annexure Roman 4A, bracket close, and the release order dated 29/2024, bracket annexure 4B, bracket close, were also issued with concurrence and or approval of this court, inverted comma close, should be read as, however, it is stated that the release order in favor of the petitioner dated 18/9/2024, bracket annexure 4A, bracket close, and release order dated 29/2024, bracket annexure 4B, bracket close, were also issued without concurrence and or approval of this court. Full stop. He therefore submitted that this typographical mistake which had occurred in the said paragraph be allowed to be corrected by hand, comma, liberty, full stop. He therefore submits that he may be given the liberty to correct the same by hand, full stop. This court duly permits the learned counsel appearing on behalf of the respondent number 2 to correct the same by hand and certify the same by way of an initial. Mr. D. Das, the learned senior counsel appearing on behalf of the petitioner submits that in view of the fact that recently 3 affidavits have been filed by the respondent number 1, 2, and 4, comma, the petitioner would be given a liberty to file the affidavits within by on or before 29th of May 2025. This court accordingly fixed the matter on 5th of June 2025 at the top of the list. In the meantime, the petitioner is given the liberty to file their affidavits in replies to the affidavit in oppositions filed by the respondent authorities. Mr. S.R. Rabha, who appears on behalf of the respondent number 5, submits that in view of the stand which has been taken by the government in the government of Arunachal Pradesh in the affidavit filed by the respondent number 1, he would obtain further instructions and place it before the court. List according.
Now daily list item 9.
We'll have
We
it at the
continue.
top of the list on 5th, finish it.
2 o'clock.
Top of the list is
10:30.
item 1.
I'm deeply obsessed.
Daily list item 9.
And what is the second ground?
The second ground was, my lord, this advertisement all over Assam, the all district judicial establishment, my lord, they all are inconsistent, my lord.
I'm not, that, how is it relevant?
Well, in some district, it is HSLC, HS, higher secondary passed, somewhere it is like the HS not passed. There are some serious inconsistencies everywhere, and I have given a list, my lord. If your lordship can come to page 10 of.
This advertisement is done in terms with the Guwahati High Court's notification dated
That
28th of.
No, that notification is not applicable to district judiciary.
Why?
This application is pertaining to High Court Rules 1964.
No, there is another notification.
My lord, so far the notification dated, lordship is taking notification dated 28 January 16, I suppose.
No, this is, there is another notification of 4th of January 2021.
4th of January 2021.
Pending framing and or approval of the rules governing the eligibility criteria for appointment to the post of grade 4 in the subordinate courts within the state of Assam, selection process for appointment to those posts in the subordinate Iman shall be governed by the rules framed applicable in the principal seat of the Guwahati High Court and its outline notified by the notification dated 28/1/2016 and pending for such framing and approval. So, this is
My lord,
being
if I read the 28 January 2016 notice, if I may read, my lord, in exercise of the power conferred under Article 2 Constitution.
Mr. Samua, this is not necessary because this categorically says what is the eligibility criteria, and this has been incorporated to the subordinate judiciary.
My lord, if your lordship goes into it, my lord, this, lordship is having this January 28, 2016 notification, my lord. This notification is an amendment to the rules 6 subsection D of the High Court Service Conduct Service Rules, 1967.
Hmm.
1967 is for the principal sit on outlying benches.
Mr. Counsel, why you are not understanding what am I saying? This is the rule. This is the notification of 28/1/2016.
Yes.
But this has been incorporated into the subordinate judiciary by the 4th of January 2021 notification. Hello, hello. Heard Mr. A. Samua, the learned counsel appearing on behalf of the petitioner. Mr. Government, Mr. T.R. Gogoi appears on behalf of the respondent number 1. Mr. H.K. Das appears on behalf of the respondent number 2, 3, and 4. Pusto. The petitioner herein has approached this court by filing an instant writ, has approached this court by invoking the extraordinary jurisdiction under Article 26 of the Constitution, challenging the advertisement dated 19/9/2023, and further seeking a direction upon the respondent number 4 to re-advertise the post with modified conditions by removing the upper limit of educational qualifications for the post of peon in the establishment of the District and Session Judge Bongaigaon Assam. Pusto. It is relevant to take note of that on 19th of September 2023, the district the facts as could be seen from the materials on record would show that on 19th of September 2023, the District and Session Judge Bongaigaon, the respondent number 4 herein, had issued an advertisement for filling up of 2 vacant posts of office peon. Office peon in the establishment of the District and Session Judge Bongaigaon. The requisite qualifications stipulated in the said advertisement is, inverted comma, class Roman 8 passed, full stop, bracket, HSSLC passed or above shall be ineligible, bracket closed, full stop. The learned counsel appearing on behalf of the petitioner submitted that the limiting of the qualification by the impugned advertisement is in violation to Article 14 and 16 of the Constitution, and in that regard have referred to the judgment of the Supreme Court in the case of Muhammad Rizwal Usman Ghani and others versus District and Session Judge Nagpur and others. He therefore submitted that the minimum of the limiting of the said qualification to those candidates who have not passed HSSLC is required to be interfered with. The learned counsel further submitted that the said qualification that the district is that the district judges establishment in various districts of the under this High Court have been issuing different advertisements containing different qualifications, and as such, the said impugned advertisement dated 19/9/2023 is required to be interfered with. Per contra, Mr. H.K. Das, appearing on behalf of the petitioner, respondent numbers 2, 3, and 4, submitted that that in a recent judgment of the Supreme Court in the case of Chief Manager, Punjab and National Bank and another versus Anit Kumar Das, the three judges bench reported in 2021 12 SCC 80, a three judges bench of the Supreme Court, after taking into consideration the judgment in the case of Muhammad Riazul Usman Ghani Supra, had observed that it is for the employer to determine and decide the relevancy and the suitability of the qualification for any post, and it is not for the courts to consider and assess. Full stop. He further submitted that the advertisement so issued, the impugned advertisement so issued, is in consonance with the notification dated 4/1/2021 issued by the Register of Vigilance of the Guwahati High Court, whereby the Rule 6D of the Guwahati High Court Services (appointment, conditions of service and conduct (Rules 1967) was incorporated to the provisions of incorporated and applied for stipulating the eligibility criteria for appointment to the post of grade 4 in the subordinate courts within the state of Assam. This court have duly heard the learned counsels appearing on behalf of the parties and have given an anxious consideration. From a perusal of the advertisement dated 19th of September 2023, impugned in the instant proceedings, it is seen that the requisite qualifications set out therein for the candidates to apply for the two posts of office peon is class 8 passed, and the said candidate have not passed HSSLC or above. This court finds it relevant to take note of the judgment referred to by the learned counsel for the petitioner in the case of Muhammad Riazul Usman Ghani Supra, wherein the Supreme Court, wherein a two judges bench of the Supreme Court at paragraph number 21 had observed that a criterion which has the effect of denying a candidate his right to be considered for the post on the principle that he is having a higher qualification than prescribed cannot be rational. It is, however, relevant to take note of that in paragraph number 21, also, the Supreme Court had observed that the said statement is being made, the said observations was made on the facts of the case in hand therein, and should not be understood as laying down a rule of universal application. This court further finds it relevant to take note of the judgment in the case of the Chief Manager, Punjab and National Bank, Supra, wherein a three judges bench of the Supreme Court after taking into consideration the various judgments of the Supreme Court on the question of having a limit in limiting the educational qualifications to a particular post observed at paragraph 17.3 as hereinunder. The above observed hereinunder paragraph 17. The said paragraph 17.3 is reproduced herein as hereinunder. Do we apply to reproduce? A perusal of the above paragraph categorically observes that it is the employer who has the right to determine and decide the relevancy and suitability of the qualification for any post. And it is not for the courts to consider and assess. It is further observed that a greater latitude is required to be permitted by the courts for the employer to prescribe the qualifications for any post. The Supreme Court categorically observed that qualifications are prescribed keeping in view the need and the interest of an institution or an industry or an establishment, as the case may be, and the court and it is not the role or function of judicial review to expand upon the ambit of the prescribed qualifications. It is relevant to take note of that in the said case before the Supreme Court, in the said case, that is in Chief Manager Punjab and National Bank and another Supra, the Supreme Court was dealing with the aspect of prescribing the eligibility criteria oblique educational qualification that a graduate candidate shall not be eligible and the candidate must have passed 12 standard. The Supreme Court observed that the said prescription of the eligibility criteria oblique the educational qualification could not have been interfered with by the High Court. And thereby to permit, would not have been interfered by the High Court and permit the appellant bank therein to allow the respondent, that is the writ petitioner, to discharge his duties as a peon. Full stop. Taking into account the said observations, this court further takes note of taking the said here. This court further taking into consideration the observations made by the Supreme Court in the case of Chief Manager Punjab and National Bank and another Supra, it is therefore the opinion of this court that the decisions so taken to prescribe the educational qualification of class 8 pass and those who are HSSLC passed or above shall not be eligible, cannot be interfered with in exercise of the powers of judicial review. Full stop. Let this court now take this next submission so made by the learned counsel appearing on behalf of the petitioner, that there is no uniformity in the prescribing of the requisite qualification by the subordinate judiciary under the Guwahati High Court. Full stop. This court finds it relevant to take note of that that by the notification dated 28/1/2016, the Chief Justice, in exercise of its powers under Article 229 of the Constitution, had prescribed the qualifications, eligibility criteria / qualifications for appointment of persons in grade 4 bracket group D post in the principal seat of the Guwahati High Court and its outlying branches. Full stop. The said notification being relevant is reproduced hereunder in the High Court of Register General. Full stop. It is further seen that by another notification number 1 dated 4/1/2021, the provision of Rule 60 of the Guwahati High Court Service bracket appointment, condition of service and conduct bracket close rules 1967 was made applicable as eligibility criteria for appointment to the post of grade 4 in subordinate courts within the state of Assam. Full stop. The notification number 1 dated 4/1, the contents of the notification number 1 dated 4/1/2021 being relevant is reproduced hereunder. The email to Nalage.
My lord, may I add
From-
one submission to this, my lord. Regarding this notification, Lordship may be pleased to add one submission from my side, that this notification of 4th January cannot be issued by the Honorable Chief Justice by exercise the power of under Article 229, because 229 is for the.
Mr. Samo, kindly don't make that submission. People will laugh. You see, this notification is not made by the Chief Justice. This is made by the High Court.
That is what, my lord, this is with the approval of the Chief Justice. Otherwise-
No. This will be made by the High Court. Kindly appreciate, there are two different things. When it comes to 229, it is the Chief Justice. 235, it is the High Court. And the High Court, if you see the definition, what is a High Court is given in Article 367. It means what is the High Court? And High Court means the full court. So this is the full court's resolution. Don't make that submission. It will show very badly. I have delivered one judgment on a very important point as regards in the principal seat. The question was as regards whether a person who is from an outlying bench can be brought in the principal seat as a registered establishment. The question was that. So in that judgment, I have referred to all these things very clearly. And this arises from another judgment of the Supreme Court in the case of, in Rajasthan, what was happening was that a person concerned was, there's a, what you call, he was terminated or something to the effect. Who was in the subordinate judiciary. The question was whether the Chief Justice could have done it. And the Supreme Court dealt with Article 229 and 235 and say, for the purpose of subordinate judiciary, the Chief Justice could not have. But there was a full court resolution empowering the Chief Justice to do that. And because of that, he had done it, not on the basis of anything. But this is not on the basis of that. This is a full court. Because the full pending framing or approval of the rules, this has to be done by the state.
Yes.
And the power is to be exercised only by the High Court. That is the full court, not the Chief Justice. Is it?
Yes.
দেখো কি লিখিলো এইটো পাহৰি গলো ক'ত কৰিলে full stop. Should I put that submission? Mr. Samoa, should I put that submission? You wanted, I can put
No, no, it's all right, madam.
full stop. Taking into account the above, let this court see what is the qualification eligibility criteria set out in the notification dated 28/1/2016, which was made applicable to the subordinate judiciary, to the district judiciary, to the district judiciary, district courts of Assam. Full stop. From a perusal of the said condition, it transpires that for the post of grade 4, class 4/group D, the candidate must possess the minimum educational qualification of class 8 standard, and those who have passed HSSLC or above shall be ineligible to apply for the said post. Full stop. Taking into account the said notification, taking into account the above, and applying the same to the impugned advertisement, it would be seen that the requisite qualification has been put in accordance with the notification dated 28/1/2016. Read with the notification number 1 dated 4/1/2021. So considering the above, the second submission therefore made by the learned counsel for the petitioner cannot be accepted. Accordingly, this court finds no ground for interfering issuance of any writ in the instant matter for which the instant petition stands dismissed. The respondents are at liberty to proceed further with the advertisements which was issued, if not already done. এই দুখন লাগিব এইখন ভয়
Item 10. Item 10.
Yes, what is this, Guwahati High Court? What is it challenging?
They are challenging the appointment of the private respondent.
Huh?
They are challenging the appointment of the private respondent
Appointment to?
to the post of office peon reserved for SC and ST.
Not. Why?
That the process, they haven't challenged the process per se. Challenge the result, my lord.
Where's the advertisement?
Page, my lord, 21 of the lordship's brief.
So there are two posts, office peon,
Yes.
SC1 and STH1.
Yes.
Okay. What is the name of the petitioner?
Kamkolen Lojen.
She is,
Her marks in the written test, my lord, at page 29. She's ST Hill,
page,
page 29, lordship.
32. And the
In the
other
written
one,
test,
and the
in the written
petitioner?
test.
And respond number 5 is, this one long sir, where is he?
Well, respondent number 5 is. His marks, my lord. This one thing now, my lord, this is
Huh?
basing around far. The page 30, my lord, written test, serial number 17.
12,
Yes, page number 30, his marks.
12.
Yes, my lord.
Then why did you appoint her?
Well, there was a written test. The written test was for screening. And after that, there was the oral interview. And the other person had secured more marks in the interview. Page 34 of your lordship's brief. He had secured 56 and she had secured 51.
56.
Yes,
So how many marks did you have for interview?
60, my lord, in all. 3 persons were there.
60 for interview
Yes,
and 40 for written.
yes, my lord.
It's the other way around. Huh? It is permissible. This is same like that case which that day I had dismissed, allowed. What is the name of the petitioner?
Kamkol and Lojan. Lordship.
51 and 56
Yes, ma'am.
and 18. 18 you are not taking. Huh? What is this examination?
That is,
Who have secured marks. So you have not taken
S.
this 32.
that is for SC, my lord.
Huh?
That is for SC.
Now understood. List of candidates who secured marks in written test held on 25-2.
Yes.
Page 29.
Yes. Category
Petitioner
SC.
gets 32
Yes.
and the respondent gets 12. Okay. Then marks complied obtained who appeared for the post in viva voce.
Yes.
Now the petitioner gets
51
51 and the respondent
respondent
gets
gets
56. Then how do you make the difference? So you add both. This person has become 80 something and this has he has got only 68.
But the stand in the affidavit, if I may draw your lordship's attention to it. Well, paragraph 4, my lord. And then
Yeah.
paragraph 5.
That it is not correct. The petitioner obtained 38 out of 50 marks, whereas respondent number 5 have got 12 marks out here. Thereafter the petitioner.
Page
What is the
30.
marks?
Marks, total marks, my lord, written was 40.
No, what do you say about this document? At page 29. This is signed by the Chief Judicial Magistrate.
Yes, my lord. This
What is this? How is it possible?
This was an examination which was carried out to screen out because there were a number of candidates, my lord. The stand in the affidavit, my lord.
So then a
And
person who is there 12, you have brought him there. Means a person has to get 0.
That's what it says.
You
my lord.
want to screen him very well. So where is there in the advertisement?
Advertisement at page 21, my lord.
Where does it say screening? What is the selection procedure?
Not spelled out. It is there, my lord.
Where?
Page 22. Common written test of 50 marks.
And viva voce of 20 marks.
Yes.
Then where are you giving 60 marks to this person?
3 persons on the interview, my lord.
So you give 60 marks there. You can have an average of 60 marks.
True.
Absolutely encourages. That is why the petitioner counsel is not there, having lost total faith in the judicial system. The judiciary can do this type of things. So without the petitioner also one should allow this petition. What is this? And the sad part is, I'm the portfolio judge of this district. Thank goodness. The action of these officials should be deprecated. How on earth? This is the selection procedure. 50 marks and 20 marks.
Yes.
We set aside this. You are there? Yes, he is seeing the court's favorable opinion, he jumps from somewhere.
I apologize, Lordship. Lordship, we have challenged in this petition regarding the appointment of respondent number 5. Lordship, we have taken dusty service, but respondent number 5 refused to accept.
Has there been a stay?
No, Lordship.
No stay. Hello.
Lordship may
Mr.
kindly
President.
allow us to take dusty.
What
service.
about the respondent number 5?
Respondent number 5, Lordship, Bison Singer. We have challenged the appointment of respondent number 5.
Hello, we do one thing.
Yeah.
It is seen that the service upon the respondent number 5 is not complete. Is it complete?
We have Lordship taken dusty service, but
Then-
he refused to accept it.
You have not filed the affidavit of dusty? Unnecessary, wait. It is seen that the service upon the respondent number 5 is not complete. Madam, is the respondent number 5 working under you? Good stuff. It has been submitted by Mr. Sharma that the respondent number 5 is presently working, isn't he? Has he been issued an appointment order or not?
That, my lord, the affidavit is silent on that. My lord.
He's wrong.
It just says the result.
You cannot be so. What is wrong with the judges? And madam, you have to be also careful. So this resolution which was adopted when 5/9/2024 was pursuant to the advertisement. So it goes against the very advertisement also. Or is it against this advertisement or this one?
Against the advertisement, Lordship.
No, this cannot be. What is the date of this? Minutes? 25/4/2024. And thereupon they passed this on 1st of July. Isn't it?
Yes.
Now, is it against the same post? Against this advertisement? Once you have stated the selection process in the advertisement, how can you change it? Gross violation. Anyways, is he working or not? Find it out. Call up 3 o'clock. We'll serve it through here and fix it. Repetition will be allowed on 12th.
Lordship may kindly allow to take us registered by registered post.
Not necessary. You have a photocopy? Photocopy of a petition, do you have it or not?
Yes, Lordship.
Get it by 3 o'clock, if you don't have. Next.
11,
For this matter,
There are now two
the
rules
different
which have
one.
been brought on record.
Huh?
Two different rules. Lordship says page 57 for a moment, madam. I'm sorry, page 56. This is the rule we depended upon for process server. Lordship has the last serial number 19
No, why the matter has come up today?
for admission, madam. But the
Has been
Guwahati
received
High
from
Court
the
has not
respondent number
filed their
2 and
affidavit.
3. Who is respondent number 2 and 3? Important?
Yes, madam, the Guwahati High Court.
Huh?
Registrar General and the Registrar General. The
Who is
confusion
appearing for
that
the High Court? You're not filing affidavits? Okay, you don't want to file, very well. What about respondent number 7? Has he filed it?
5 and 6 are
So you
filed,
don't
madam.
want to file it. So what about respondent number 7 who is appearing? Is the service upon respondent number 7 is over?
That's the last time I checked, yes.
Could not be sent. As rupees 24 worth of lesser Korea was given. Oh, service is not complete. What to do?
I have it done today, madam.
Is it working?
Yes, yes.
Respondent number 7 is working. Okay. It is seen that the service upon the respondent number 7 is not complete. Good stuff. Mr. R. Majumdar submits, the learned counsel for the petitioner submits that he may be permitted to effect service upon the respondent number 7 through the district and session judge, through the chief judicial magistrate Borpeta, who is being duly represented by Ms. S. Sharma in this court. So taking into account the above, this court directs the counsel appearing on behalf of the petitioner to serve an extra copy of the writ petition upon Ms. S. Sharma during the course of the day.
Right.
Full stop. Ms. S. Sharma shall effect service upon full stop. Ms. S. Sharma, the learned counsel representing the respondent number 5, shall ensure that the respondent number 5 effects service upon the respondent number 7 as he is working, as the respondent number 7 is working in the establishment of the respondent number 5, and submit a report before this court on the next date fixed hereinunder. Full stop. List this matter on 19th of June 2025. Full stop. In the meantime, the respondent number, the respondent number 7 is also given the liberty to file the affidavit in opposition. And you are not filing affidavit 2 and 3. I'll note it down.
Yeah.
Good.
The absence of the affidavit, my lord, this case will be paid. In the absence of their affidavit, there will be problem in, my lord, adjudicating the matter.
They don't file for me to pass the order. It is observed that this court further grants a final opportunity to the respondent number 2 and 3 to file the affidavit on or before the next date, failing which this court shall take up the instant proceedings for disposal on the basis of the materials available on the court.
12,
IAS file for correcting your important errors, Your Honor.
Wait, what is your case?
This is for overpayment of
It
pay.
aggrieved, yes, I have informed the resident that the arrange a pay of rupees a month for the petitioner after recovery of the amount. for payment. Why are you challenging?
Lordship.
Why are you challenging?
Challenging for overpayment of pay and allowance to the petitioner during his service period.
Is sought to be taken away
Yes, Lordship.
after your retirement.
Yes, Your Lordship.
So your case is Rafiq Masi,
Yes,
paragraph 18.
yes, Your Lordship.
When did you make the deduction? What did you do?
Yes, Lordship.
How did your retirement set? What is your post?
My post is upper division assist.
Huh?
in, Guwahati
Mhm.
Kamrup.
Then,
Then after I retired on 31st/12/2021.
so
Then they are deducting our money from the pensionary benefit. Your Lord. They are deducting our money from our pensionary benefit, from my pensionary benefit.
but why did you write that letter?
It's not,
You have written a letter
yes, Lordship.
that you have no objection.
I have not inserted about this, Lordship.
You file an affidavit. Mr. B. Chakraborty, appearing on behalf of the senior, appearing on behalf of the respondent number 4, respondent number 3 and 4, submits that he would file an affidavit in the incident matter, taking into account the above, the list this matter again on we finish it off on 19th of June 2025. In the meantime, the affidavit be filed by the respondent without fail. What is this IA business?
I is for the correction.
What correction?
Correction, there is a respondent number 2345 has wrongly written as in respondent number 3456.
Okay. This is an application filed by the petitioner seeking correction of the numbering of the respondents in the accompanying writ petition at the various pages, at the various paragraphs of the writ petition. This is an amendment application.
Yes, Lordship.
How can you file this type of amendment like this? You have to say. Anyways, we are concerned with not that. I let it with you. You file your affidavit being.
Much obliged.
Oh. Look at us, 13 আছে না? তো কই 13 তে শেষ করব।
13.
Here the respondent number 2 and 3 have.
Oh,
filed
this
their-
case?
Yes,
Yes.
the date of joining, 2 and 3 have filed their affidavit, I'll file my reply.
Why? With the question. When the High Court say, isn't that the case? When the High Court say that you kindly appoint both of them, why you selectively appointed the number 3 before the number 2? That's his case. Why? It's illegal. And therefore he cannot lose his seniority. There's nothing to say. He's absolutely wrong. Why do you need to file a reply? He also admits. Isn't it, Mr. Bushra? No. I'm concerned with, forget about the notification. Kindly see his order. This notification. Kindly see the High Court writing at Annexure 4, page 44. As directed, I am to inform you that the following candidates have been provisionally selected for appointment in your establishment area. You are requested to issue appointment to the concerned imam and after issuing initiate police verification. So you issue the notification for Pranjit Bonik and Lipika Rani Tait first and then Pranjit Bonik. Why? What is your explanation? Because you like.
In the
Is it
affidavit, they
this?
say she went to the office earlier.
Huh?
In the affidavit, they say she went to the office one day earlier to me.
So,
Therefore, she gave.
Is
she
it
got
mentioned somewhere that the person has to go there? He has the time to join within 15 days. So if he has a time to join, you should have issued the appointment order together. And then it will go as per the seniority. And if he joins within the 15 days or for the subsequent period, which is being allowed on the act of God, then he can get the benefit of his seniority. This can't happen. Who is appearing for the respondent? Oh, what is your case? You don't have a case. These gross illegalities by the Ms. So-and-so, appearing on behalf of the respondent number 5, submits that the respondent number 5 have already received the documents and would be filing the affidavit on or before 29th of May 30th of May 2025. List the matter again on 5th of June 2025. We finish it off on that date. This is an opportunity being given because tomorrow you may say that no opportunity was granted.
Supplementary item 18 and 19.
Reading item number 19, my lord. The interim order dated.
Not properly. So I have already talked to the registry, some more time. These 2 weeks time will also be keep now. They come up with the application.
এই কোন যাও 18 19 ইটু কোন আর এটা আছে না এটু দিও মেইন টুতে অর্ডার আছে Mr. HK Das the learn এটু 2325 ওত লিখিব দি Mr. HK Das the learned counsel appearing on behalf of the respondent number 1 and 2 submits that who is appearing for the respondent number 4 to 20? You are appearing. On behalf of the respondent numbers 1 and 2, submits that the affidavit could not be 1, 2, and 3, the 2 and 3, 1 and 2, submits that the affidavit could not be filed on account of the want of instructions. Mr. So-and-so, he does, as does, appearing on behalf of the respondent numbers 4 to 20, also 6 time for filing the affidavit. Taking into account the above, list this matter again on how much time? Give me a date when you are filing. It can't go delayed.
No, it will not be delayed. 19 June.
It is too late. There is not 2 weeks.
12 June.
12 June. Because this court, therefore, fixes the matter again on 26th, 19th of June, 26th of June. Full stop. By 12th of June, the petitioners are given the liberty to file their affidavits. The respondents are given the liberty to file their affidavits. Full stop. If such affidavits are filed on or before the next, by 12th of affidavit, 12th of June, the petitioner shall file, if so advised, would be at liberty to file their reply on or before 23rd of June 2025. Full stop. List the matter on 26th of June 2025 for final disposal at the admission column. Full stop. The interim order passed on 1/5/2025 shall continue till then. Economist, you are filing affidavit here also. Mr. H.K. Das submits that he is going to file the affidavit in the instant proceedings by same date going, by 12th of June 2025. You are appearing for the others. Mr. P. Das, S. Das, appearing on behalf of the respondent number 3, 4, 5, and 6. Are you sure? Submits that he would also file the affidavit. Who's taking into account the respondents are given liberty to file the affidavit by 12th of June 2025. The petitioner, if so advised, would be at liberty to file the affidavit on or before 23rd of June 2025. List the matter on 26th of June 2025 for final disposal.
On 26th, I have some difficulty, madam. It may be on 27, man. 27.
I don't go by that. We have more than 1 month. Ask your client to engage some other lawyer. Order 17 Rule 1 applies.
No, there is no.
Mr. Das, I don't understand how the High Court is permitting this type of appointments. Do you know the impact of that letter with the appointment order?
After 10 years, finance doesn't give approval and this person continues. And if we want to discontinue his service, he will come up with a petition saying that, look, here I have worked for 10 years. As per Jaggu, regularize our service. That is the recommendation. It's correct.
And we make it very clear. When the High Court has made it very clear in respect to these type of appointments, that when you are appointing on a contractual basis, you have to fix the period. Just for example, a person is being appointed from 1/4/2023 or 24 or 25. He'll be appointed, his appointment will be for 11 months or 12 months, whatever it is. Then there is a gap period of 1 or 2 days, and then a fresh appointment is being given. This is how it is regulated. This is absolutely illegal.
So far as this gap is concerned, this artificial break has been deprecated by the Honorable Apex Court. I'm not on that. But there has to be an agreement. There is no iota of doubt with the agreement. If it's a contractual, there has to be an agreement, 11 months or whatever month, it has to be extended by executive of the section. Look, I'm not. That is not now.
No, not on that. You had 2 eligibility lists. In one eligibility list, his name is not there in the office peon contract. He has his right to be appointed, considered to be appointed has been gone.
To get the proof from where people will go. The law is also well settled. Even my name appears in the select list, I don't have any right. Now this pool was created. Yes, The respondent number 4 did not submit application for contractual. But if that pool is there and if someone gets selected from that pool, what is wrong? It will not confer you any right. You are not at all prejudiced. You
We do one thing. Mr. Das, what I do one thing is, I allow the repetition with cost of 25,000 upon the Guwahati High Court, which will be paid by the High Court to the petitioner for the litigation expenses, and the High Court will recover it from the officer. This will be the order which I am passing. No, that cost will be there, which will be recovered from that officer concerned. Because he has been unduly, if you otherwise he would have otherwise got the job.
No, he was in execution fee.
It doesn't apply because 3 and 4 was not there. 3 and 4 never applied. So therefore his right have been taken away. Otherwise he would have been the person who would have been the official contractual employee. So therefore you pay 25,000, recover from the officer, the district judge who have done this. This is the order which I am passing. Then they will realize that one has to be very careful in doing all these things. Heard Mr. K. Sharma, the learned counsel, appearing on behalf of the petitioner. Mr. H. K. Das appears on behalf of the respondent numbers 2, 2. Stop. Respondent number 2 and Mr. T. R. Gogoi, Ms. D. Bormon appears for the respondent number 1. Mr. H. K. Das appears for respondent number 2. Who appears for you? So and so appears for the respondent number 3, and Mr. So and so appears for the 4. None appears on behalf of the respondent number 4. Full stop. The petitioner have assailed the appointment of the respondent number 3 to the post of the office peon contractual, primarily on the ground that the respondent number 3 was appointed to the said post without there being any application filed for the post of the office peon contractual. Full stop. Let this court now take up the facts which led to the filing of the instant proceedings. Full stop. It is seen from the materials on record that on 12/1/2023, an advertisement was issued by the District and Session Judge Borpeta, that is the respondent number 2. Full stop. In terms with the said advertisement, 3 posts were advertised, of which 2 posts were for office peon, which was on scale of pay. 1 for general candidates and the other for OBC. In respect to the post of office peon contractual, it was on fixed pay of rupees 15,000 per month, and it was for unreserved candidates. Full stop. The petitioner applied for both the posts by filing separate applications. And in that regard, the petitioner was issued 2 roll numbers. being roll number 32 and C-14. The respondent number 3 and 4, along with others, and respondent number 3 and 4 also applied for the post of office peon, and they were assigned roll numbers for 22 and 50 respectively. First, it is very relevant to take note of the advertisement which categorically stipulates that no application would be accepted after 10/31/2023. As would be seen in clause 11 of the advertisement dated 12/1/2023. Pursuant to the said submission of applications, the office of the respondent number 2 prepared 2 separate lists of the applications submitted to the respective posts. One was a list of candidates for the post of office peon, which contained 123 names of 123 candidates. The petitioner's name in the said list is as serial number. Yes, serial number. What is the name of the petitioner? Prabhakar Kapote. Serial number 32.
No.
Whereas
Contextual.
the name of the respondent numbers 3 and 4 were as serial numbers 20, at 22 and 50. It is very pertinent at this stage to mention that a perusal of the admit cards a perusal of the call letters which were issued on 28th of March 2023 enclosed as Annexure 5 Collie would show the respective roll numbers for the post of office peon in the scale of pay given to the candidate, given to the petitioner and the respondent numbers 3 and 4, where on the basis of the serial number maintained in the application list of in the list of candidates for the post of office peon. It is further seen that from the materials on the record, more particularly the Annexure 3, that the office of the respondent number 2 have also prepared a list for post of office peon contractual, wherein the petitioner's name is found as serial number 14, whereas there is no name wherein the names of the respondent number 3 and 4 were not there. The compilation of both the lists, which are Annexure 2 and Annexure 3 to the writ petition, therefore makes it clear that the respondent number 3 and 4 only applied for the post of office peon and not for the post of office peon contractual. And on the other hand, the petitioner applied for both the post of office peon and office peon contractual. Be that as it may, the respondent authorities, the respondent number 2, issued notices, issued call letters to the petitioner and the respondent, private respondents. It is interesting to take note of that in respect to the petitioner, the call letter specifically referred to roll number 32, which was meant for the office peon for the post of the office peon on the scale of pay, and roll number C-14, which was for the purpose of office peon contractual. Whereas, in respect to the respondent number 3 and 4, it had only were only given one roll number, that is roll number 22 and 50 respectively, on the basis of the list so prepared, which is Annexure 2 to the writ petition. It is further seen that on 31/3/2023, two persons, namely Pranjal Uza and Govinda Das, were duly selected for the purpose of the post of office peon in the scale of pay. It has been brought to the attention of the court that pursuant to the order dated 31/3/2023, the persons concerned, namely Sri Pranjal Oza and Sri Govinda Das, have already joined the said posts. However, in respect to the office peon contractual, the respondent number 3's name was shown and the petitioner was put at serial number 2 of the waiting list. Being aggrieved, the petitioner submitted a representation to the district and session judge Borpeta, which was rejected by the communication dated 4/4/2023. And it is under such circumstances the present writ petition has been filed. It is seen that pursuant to filing of the instant writ petition, this court issued notice but there was no issued notice on 24/5/2023, but there was no interim order passed. The record reveals that the respondent number 2 has filed an affidavit in opposition. The stand so taken in the said affidavit in opposition is, as the advertisement did not specify that for the post of office peon in the scale of pay, as well as the office peon contractual, requires separate applications. The respondent number 2 had considered the applications of all the candidates who submitted for the three posts, for the post of office peon in the scale of pay, as well as office peon contractual. It was also mentioned that the list so prepared was for the enclosed as Annexure 2 and 3, whether for the sake of convenience, administrative convenience. The petitioner thereupon submitted a reply reiterating its statements made in the writ petition. It was further mentioned that not having a separate selection process for the office peon in the scale of pay with the office peon contractual in itself makes the entire selection process bad in law and required to be interfered with. In the backdrop of the above, this court, while hearing the learned counsels appearing on behalf of the petitioners, parties, inquired with the learned counsel who represents the respondent number 3 as to whether the respondent number 3 was appointed pursuant to the order dated 31/3/2023. First, the learned counsel appearing on behalf of the respondent number 3 submitted. I have to justify why I am imposing cost upon him of 25,000. No, I should make it 50. The learned counsel appearing on behalf of the respondent number 3 had produced a copy of the order dated 5/4/2023, by which the respondent number 3 was appointed to the post of office peon contractual in the establishment of the district and session judge Borpeta. First, the contents of the order dated 5/4/2023 being relevant for the purpose of the instant dispute is reproduced herein under. This court, during the course of the hearing, inquired with the standing counsel of the Guwahati High Court, as well as the learned counsel appearing on behalf of the respondent number 3 as to whether the order dated 5/4/2023, whereby the petitioner respondent number 3 was appointed, was supplemented with an agreement fixing a particular period for appointment. First, both the counsels submitted that there is no such agreement. First, in the backdrop of the above, let this court now consider the respective submissions so made by the learned counsels appearing on behalf of the parties. First, it is seen from the advertisement dated 12/1/2023, the post of the office peon, which is in the scale of pay, has been put at serial number 1, whereas the office peon contractual has been put at serial number 2. It is further seen that in the advertisement dated 12 in the advertisement dated 12/1/2023, it has been categorically mentioned with the words inverted comma, intending candidates shall submit their applications in the standard form of application to the undersigned on or before 30/1/2023, along with all the testimonials, inverted comma closed. The use of the word intending candidate in the singular, followed by the word applications to be filed in plural, makes it very clear that for each post, that is office peon in the scale of pay and office peon contractual, separate applications are required to be filed. This aspect of the matter is further clear from the fact that the office of the respondent number 2 has prepared 2 separate lists. One for the list of candidates for the post of office peon in the scale of pay, and one for the list of candidates for office peon contractual. Full stop. Those candidates who were in the list of candidates for the post of office peon in the scale of pay were provided roll numbers on the basis of their number serial number in the list of candidates for the post of office peon in the scale of pay. And those candidates who have applied for the office peon contractual were issued roll numbers as per the list, as per the serial number of the list of the candidates for the post of the office peon contractual, with the word C mentioned prior to the serial number, which the petitioner herein having applied for the petitioner as well as the respondent number 3 and 4 having applied for the post of office peon in the scale of pay were accorded the roll numbers (32, 22, and 50). Insofar as the selection for the post of the list for the post of the office peon in the scale of pay, and the petitioner who have applied for also applied for the post of the office peon contractual was granted the roll number C-14. Full stop. This aspect of the matter would be further clear from a reading of Annexure 5, Collie, wherein the respondent number 2 had issued call letters. But surprisingly, at page 30 and 31, call letters, where you should call letters. Full stop. This court further finds it very pertinent to take note of clause 11 of the advertisement, which categorically stipulates that no application would be accepted after 31/2023. And taking into account Annexure 2 and 3, which are the lists so prepared, it is apparent that the respondent number 3 and 4 did not apply for the post of the office beyond contractual prior to, on or before 31/2023. Under such circumstances, it is therefore the opinion of this court that the respondent number 2 could not have appointed the petition respondent number 3, could not have appointed could not have selected the respondent number 3 to the post of office beyond contractual and put the respondent number 4 in the select list, in the waiting list of the select waiting list. This waiting list is not necessary. This waiting list does not say anything about the contractual appointment. It is for anything. We are not concerned with it. Could not have appointed, could not have selected the respondent number 3. Therefore, the order dated 31/3/2023, insofar as selecting the respondent number 3 to the post of office beyond contractual, is contrary to law, is contrary to Article 14 and 16, as well as even the advertisement which was issued, for which the order dated 31/3/2023, insofar as appointing the respondent number 3 to the post of the office beyond contractual, is required to be interfered with. Next. This court further is shocked and surprised in the manner in which the respondent number 2 have issued the order of appointment of the respondent number 3. Full stop. Taking into account that the post in question is a contractual post, it is beyond imagination as to how the respondent number 2 would have issued an appointment order without stipulating the period of the contract. Full stop. It is further notable, it is further unimaginable as to how the respondent number 2 have allowed the respondent number 3 to continue with the post, to have issued the order of appointment dated 5/4/2023 in favor of the respondent number 3, that too without entering into a contractual agreement. The above transgressions on the part of the respondent number 2 speaks large on the question of total non-application of mind and suffers from malice in law. Full stop. Considering the above, this court therefore disposes of the instant writ petition with the following observations and directions. Full stop. The order dated 31/3/2023, by which passed by the respondent number 2, by which the respondent number 3 was selected for the post of office beyond contractual is interfered with. Full stop. For the sake of clarity, this court observes that the selection of Sri Pranjal Oja and Govinda Das in the order dated 31/3/2023 is not interfered with. Number two, this court interferes with the order dated 5/4/2023 by which the respondent number 3 was appointed as office beyond contractual. Number 4, this court expresses its deep displeasure in the manner in which the order dated 5/4/2023 have been issued without fixing the period of the contract for which the person concerned have been appointed. The respondent number 3 was appointed for the post of office beyond contractual. This court also expresses its deep displeasure of permitting the displeasure at the actions of the respondent number 2 in issuance of the order dated 5/4/2023, that too without entering into any agreement. Next, taking into account that this court have interfered with the order of appointment dated 5/4/2023, made in favor of the respondent number 3, the post of the office beyond contractual be filled up by following the due mandate of law. Next, this court further, in the interest of justice, observes that the setting aside of the order dated 5/4/2023 by this court shall not permit the respondent authorities, more particularly the respondent numbers 1 and 2, to take any actions for recovery for the period the petitioner, the respondent number 3, had worked. Tell your district judge to be more careful next time. This type of action is, I've expressed my displeasure and this, yeah.
Appointment of the petitioner may be directed to be considered, my lord.
No, that I can't.
You are selected already.
Absolutely no. The waiting list concept is wrong. Whatever may be, wherever this person concerned, ask him, be careful this time.
Item 10.
Actual appointment being appointed without a period.
And this person has been working, the private respondent, pursuant to the order dated 1/4.
It is seen that the service upon the respondent number 5, na?
Number 5.
5 is not complete. Full stop. The learned counsel appearing on behalf of the petitioner, appearing on behalf of the Guwahati High Court, the learned standing Ms. S. Sharma appearing on behalf of the Guwahati High Court submits that the respondent number 5 is presently working under the establishment of the respondent number.
No, my lord.
Establishment
four.
of the respondent number 4.
Oh, my lord.
Full stop. Taking into account the above, the petitioner is directed to furnish an extra copy of the instant writ petition to Ms. S. Sharma during the course of the day, who shall ensure that which will ensure that the registry take effective, ensure that the copy of the writ petition is served upon the respondent number 5, and a report be submitted by the registry before this court on or before 19th of June 2025. Full stop. In the meantime, the respondent number 5 is given the opportunity to bring on record his stand by filing an affidavit list and matter on 19th of June 2025 for further consideration.
Item 6.
Mr. I won't take up this matter today. Mr. Sen, we'll take up the matter some other day. Today a High Court matter, huh? But when should I take it? Any convenient day? When?
12th of June, my lord.
No, my lord.
12th of June, as your lordship. 12th of June.
16 or 17, my lord. 16 or 17.
When?
16 or 17.
No, not necessary. We'll have it on any other day on 28th of May.
28, my lord, I am having engagement, my lord, outside.
3rd of June, my lord. 3rd of June.
Third, no, 4th of June.
4th of
4th of June.
I shall not, I shall be.
We'll start on 4th of June.
Lord, my only request, my lord.
2025.
Only request, my lord. They have filed execution proceeding. Now, decree has been partly executed through my instruction, my lord. I have filed the stay petition along with the photographs, my lord, in the case record to show that the dwelling house as well as the boundary wall has been demolished. My lord, tendency of this. Now, only assurance from my, from the part of my, my lord, the friend, that they will not pursue the, my lord, eviction proceeding, my lord, pending.
Mr. Sen, whatever submissions you are making has to end that particular line. We have a line there. It should not further come beyond this because without substantial question of law formulated, it is between you and him that is on that side of the road.
Until and unless I am inspected, my lord. I can't give this undertaking, my lord.
No, I
I'm not
can't
before
help
the
you.
executive court.
You want it next week? I can have it. We'll have a good luck
Fourth
because
of
I'm
June?
not, I've asked the registry not to list this 4111 with me for some time. Let's there be some reprieve to the lawyers.
But I have a
Next-
full
next
trust
week-
on my friend. my
We
lord.
have it next week then.
4th of June, my lord.
Huh?
4th of June. Decree of life.
Court of it. Much.
Item 14.
There are three petitioners, who were three petitioners before your lordship. They were appointed as, my lord, stenographer grade 2. That the date of appointment, what you will find at page, appointment is that page, my lord.
Huh?
Page 21 is the appointment orders.
Hmm.
Issue is, my lord, fixation of wrong fixation of pay as per ROP 2017.
ROP,
2017. ma'am.
tell me. So this is the order by which you have been appointed in 8,000 to 35,000 PB3 with grade pay of 4,300.
Yes, my lord.
Then
My lord, in the meantime, but page 23, the notification regarding PSP principal seat pay that came into effect, my lord, in respect of pay band 3, 1,000 PSP was granted. Then, my lord, the ROP rules came into force, but fixation 2000 was not done. The fixation as per the rules were not done. Then several representations were filed. Lordship ultimately come to Lordship page 65 is the case of the petitioner which the High Court has written to the government, my lord, page 65. May I read this, my lord?
yes.
Subject, exercise of option.
Petitioner is appointed as senior personal assistant,
Yes, my lord.
8,000 to 35,000 pre-revised. Month ending November in month, initial pay 13,000 plus 8,000 plus 4,000 a year. Initial pay fixed. Basic pay so and so. Revised pay scale 22,000, 97,000, GP a month, PSP a month. Initial pay so and so. 32,000, 22,000, 9,000 plus pay. Then
My lord, next page, what should be the actual pay?
35,500 and 350.
Yes, my lord. And a request was made to condone the delay and fix the, as per that fixment
What is
table
this condone delay?
for the exercising option, my lord, under rule, ROP rule 5, there was an option to be availed with that, whether that increment on the next date of July next year, my lord. That option, my lord, that was not availed. by
Let me
the-
clarify on that, Lord. This rule came in the year 2017. And it was given effect from 1st of April 2016. Now persons belonging to this particular period from 2016 to the date of publication of the ROP, they were given the option within a period of 60 days to file an application whereby they will state whether they are praying for the increments from the date of appointment or from the date of coming into effect of this notification or from the date of next increment. So they delayed. It was filed subsequently.
But delay was, my lord, not intentional, my lord. Ultimately, in the affidavit, they have also condoned the delay. The only part is that they fixed, while fixating, the pay of principal pay allowance, that 1,000 rupees has not been taken into account. In the affidavit, it is clear, my lord. Affidavit filed.
So we are only in the PSP.
Only PSP part, my lord.
At all. Good. That day whole day I had spent on one matter with this thing only. That was stenographer, grade 3?
Grade 3 that was, my lord.
Ah, grade 3,
This is
my
grade two.
goodness. Mr. MP Sharma.
Yes, yes.
So one is, they have not been given the PSP.
Yes, sir. Lordship, if Lordship takes the affidavit. filed
Why
by-
the PSP is not paid?
But they have not, excluding PSP, they have taken in the fitments table 1.4. Had that 1,000 be taken into, Lordship, I kindly turn to the affidavit, my lord. Their explanation. Affidavit filed by the finance, my lord. At page 79,
Page?
internal, running page 79. Paragraph 10. May I read, my lord? As regards the statements made in paragraph number 17 and 18 of the petition, the deponent begs justice has never been denied to the petitioners. Finance PRU department agrees to condone the delay towards exercising of option as per Rule 5 of ROP 2017, and the initial pay fixation in respect of senior personnel assistant is rupees 34,320 as calculated below. On the date of increment, that is 1st of July 2017, basic pay in PB3, 8,000 to 35,000, GP.
Here they have therefore taken everything.
Yes. While
They have not taken 1,000 something, some missing is there.
Yes, my lord.
320 has become
that
4,320 they have given. It, as per them, it is 35,350.
yes, had that lordship at page 79, had they calculated 1,000, it would have been 13,699.
Page?
Page 79, my lord,
Ah.
down below. Lordship has seen 12,699 plus 1,000 PSP. Without adding that, they have fixed at the stage 3, 13,050 plus PSP of 1,000. Because since PSP.
So you mean to say it should be this 12,699
plus 1,000.
plus 1,000 should be taken
Yes.
into account for arriving at 13,000.
Yes, my lord. Then in that case, it would
And
be
this 1,000 should not be taken separately.
separately. Ma'am. That is my case, precisely. Ma'am. And that's what the High Court has stated, my lord.
So therefore, the question is 13,000. It should have been taken as 13,000, 14,050.
Yes, my lord. In the next stage, it would have gone to the next stage at table 1.15, stage 5.
Where?
At the fitment table at page 86 of the same affidavit, my lord.
$13,000.
Because, my lord, had that 1,000 been taken into account, it would have been, my lord, 13,699, which is more than stage 4 and nearer to stage 5, my lord. Page
Page
86.
4. So you mean to say it should be 13,000, it will be how much? 14,000?
It should be, my lord,
12,000,
13,000.
no, 12,699 plus 1,000,
1,000.
that is,
That
what
is
is this
13,699.
they have put it, why 13,050 they have made it?
Because, my lord, without taking PSP, 12,699 is nearer to that next table, my lord, as per
13,000, okay. So
at
if
page,
you,
at stage
if it
3, my
is
lord.
taken, that is, it is 13,600, 700.
Yes, my lord.
Almost 13,700 is taken to be nearer to 13,860.
Yes, my lord, that is stage
35,350.
Yes. That is my case.
Now, why they are not taking the PSP?
But that is the fault there, because as per the notification of PSP, it is a part, lordship, it is makes clear, my lord, the notification, if your lordship turns to page 23.
So small matter, it is so lying. Yes, what is this PSP business?
But I am reading, my lord,
The principal pays seat pay to the officers and staff of the Guwahati High Court will be notionally given effect from 1/1/2016. 6, and it will be counted for areas with effect from Iman in addition to the benefits so and so. Shall be paid as a part of the current salary with effect from 1/8/2016. And the area from Iman shall be paid in the Iman. Oh,
paragraph 2, my lord.
so therefore, will be taken as a part with effect from 1/8/2016.
But a paragraph 2 says, principal seat pay shall be admissible to the officers and staff of principal seat of the Guwahati High Court in addition to their respective pay in the pay band and grade pay for determining basic pay. That is, basic pay is equal to pay band in grade pay, pay band plus grade pay plus PSP.
So this has to be added
It has, according to the petitioner, it
as
has.
per this notification.
Yes, my lord.
This is the government of Assam notification.
Yes, my lord.
And this notification has been issued by the governor.
Yes, my lord.
So why they are not doing it? Why?
Lordship, I will explain. In respect of other, my lord, similarly situated, other computer assistants and other cadres, that has already been granted, my lord. That edition of PSP that has been.
Yes, Mr. Naik.
Lordship, please kindly come to the prayer, lordship, at page 15.
Prayer. Yes.
The prayer is directing the respondent authorities, more particularly the respondent number 1 and 2, to pass necessary order to condone the delay. That is their basic prayer in exercising option under Rule 5 and 7 of the ROP Rules 2017, so that the salary of the petitioners could be refixed at 35,350. So this is the consequential prayer, Lordship. So the first part of the prayer has already been granted. They are saying that as per their calculation, it should be 35,300, whereas as per our calculation, Lordship, it is 34,320. So the issue basically is what will be the position, her position in the fitment table, Lordship, whether it will be serial number 3 or it will be at serial number 5. And that is why, Lordship, on last date, Lordship, this matter was placed before my Lord Justice S. Shyam, Lordship.
Before?
S. Shyam, Shyam, Lordship.
Why?
No, it was earlier before his court, Lordship.
Yes.
So his statement was that, I mean, his observation was that this is not the duty of the court to fix what will be the position of a particular employee in the fitment table. And that is why he directed, place this matter before any other bench. I am not going to give any relief to that extent. I'm not on that point, Lordship. But this is my submission also, Lordship. This is highly technical, Lordship.
No, Mr. Nayak, that day, this seems to be a relief when I saw this simple matter. That day, it was such a complicated matter.
Lordship.
I'm yet to sign that order. I'm looking into it.
No.
It was a very complicated art. But taking into account the stand which have been taken by the finance department here,
Lordship.
it appears to the finance department in that earlier matter.
I will satisfy you. In this case.
No, I'm not here.
Lordship.
Taking into account the stand which has been taken by the finance department here, which seems to be, whatever may be, it's a reasonable stand. But what stand was taken in the earlier matter, absolutely incourageous stand. Means I thought that it was a very bona fide stand. It was never a bona fide stand. Because what was stated out there, I'm telling you, because you are also from the finance department. The case therein was a person concerned was appointed sometime in the month of August or September 2016. Now, as he was appointed in the scale of some scale of pay, it was said that he will be only getting that one which is being mentioned, and said that the fitment factor would not apply. And therefore, they were putting it on a particular, that it was this amount, which was the amount, plus the grade pay, some 13,000 came something, plus the grade pay, it comes to 21,700. That was the case there. On the other hand, what you have done out here, here was a person who was appointed in the month of September, October, something like that.
16.
Because this is the same period for both the cases. In this case, the period person concerned was appointed on that particular, during this period after 1/4/2016, but prior to the coming into effect of, prior to the rules being brought in, that is 17/3/2017. Because the rules were dated 17/3/2017, giving effect from 1/4. So this is the same period. Here you have said that yes, the fitment table will be applicable. This fitment table comes from multiplication with 1.86. This is how it is being done. So therefore, this aspect is more made simple. So the only issue out here is as to whether the PSP should be added for the purpose of applying the fitment factor, or without the PSP, the fitment factor is to be looked into. That's the simple question.
But I'm straight coming to the notification or fitment, PSP at page 23.
Yes.
Lordship, it comes to serial number 1. The officers and staff of Guwahati High Court principal seat will be paid principal seat pay in addition. Lordship, kindly note this word, in addition to their existing emoluments, existing pay and allowances on the following scale. I'm not on that. Lordship may come to 2, serial number 2. Principal pay sheet shall be admissible to the officers and staff of the principal seat of the Guwahati High Court in addition to their respective pay in the pay band and grade pay for determining the basic pay. That is, basic pay is equal to pay in the pay band plus grade pay plus PSP. Dearness allowance, house rent allowance, increment, this is important, Lordship, increment and pension, etc. will be paid on the basis of pay arrived at.
On the basic pay.
On the basic pay arrived at in the
amount.
aforesaid manner. So pay band and grade pay will remain the same. Only for the purpose of counting dearness allowance, house rent allowance, increment, and pension, etc. The pay, the etc. will be paid on the basic pay calculated arrived at by following this formula. Clear, Lordship? Now, in this case, Lordship, if Lordship comes to the calculation, Lordship, at page 79. So far as the condonation part is the Lordship, that has already been condoned. I am not in that. Basic pay in the pay, Lordship, I'm 10, serial number 10. Finance PRU department agreed to condone the delay towards exercising of option as per Rule 5 of ROP 2017 and the initial pay fixation in respect of senior personal assistant, that is at rupees 34,320 as calculated below. On the date of increment, that is 1st of July 2017, although.
So that is, the date of increment will be 1 year after.
But she will get that benefit from the initial date itself. That is why the option was used, Lordship. She will get the benefit from the beginning, that is from the date of effect. Coming
From
in,
1/4.
yes, but the increment will be calculated at the later stage.
This is clause 5.
Yes, Lordship may kindly see that clause 5 in it is annexed here, Lordship. Page 25. Down below, Lordship. Application of the revised.
Government employee who is in service on remand or who has been appointed on or after remand shall draw pay in the revised pay structure, pay band plus grade pay applicable to the post which he has been holding or to which he has been appointed as the case may be, provided a government employee who is in service on 31st of remand or who enters service on or after remand, but before the date of publication of the may at his option. So this is the period.
Yeah.
Before, so these rules came on 17/3.
Yeah.
Was not made, but giving effect from 1/4.
1/4.
So this is it.
In
May
between this
of the
period.
option, but before the date of publication of these rules, may at his option continue to draw pay in the existing pay structure until the date on which he earns his next or any subsequent increment in the existing pay structure or until he vacates his post or ceases to draw. The option to retain the existing pay structure under this rule shall be admissible only in respect of one existing pay structure. That is to say, in the case the employee has no lien on the permanent post area, in the case of employee having a lien on or suspended, where government, we have to go by number 3.
Lordship, second line, Lordship, at his option, continue to draw pay in the existing pay structure. He may remain at where he was until the date on which he earns his next or any subsequent increments in the existing pay structure or until he vacates the post. So she used the option, Lordship. Now this is after condoning the, although it was delay was there, it was condoned.
So this is the
And after this
increment
was
is
the
given.
calculation. Now Lordship may kindly see the calculation. On the date of increment, basic pay in the pay band 3, that is 8,000 to 35,000. Grade pay is 4,300. These are all pre-revised, Lordship. And as per the pre-revised, Lordship, basic pay was 12,300. Plus this 3% is the increment, Lordship. 3% of 13,300, that is 12,300 plus 1,000 PSP. So for the purpose of calculating the increment, this PSP was taken count of.
Or you may say 8,000 plus 4,300 plus 1,000.
Lordship may say.
No, that is how you arrive at.
No.
8,000 plus 4,300 plus 1,000 comes to 13,300.
Yes.
Because if we go to page 22 again, you see basic pay, page 22, serial number 2.
Yes.
Basic pay is equals to pay in the pay band, which is 8,000
Yes.
plus grade pay,
Plus grade pay.
4,300.
Yes.
So it is 12,300
Yes.
plus 1,000 PSP is 13,300.
Lordship. So for the purpose of calculating increment, this PSP was taken note of, taken count of. Additionally, 1,000 has been given. Lordship may kindly say PSP. So this is 12,300, 3% is 399 plus PSP, 12,699 plus 1,000. Now Lordship may kindly see what is the nearest of this 12,699 in the fitment table. Next page, Lordship, it is 13,050.
So that I've seen it. But why these all three are not added? Well, it categorically says that the basic pay has to be paid in the pay band plus grade pay plus PSP.
Yes, on the next page, next line, Lordship. So this is 13,050 plus 1,000. Next line, on revision with effect from 1/7/2017, the corresponding pre-revised scale is 13,050 is rupees 33,320 plus 1,000.
No,
Is
no,
it-
that is understood.
From there,
No, no,
lordship
but,
will
no,
come,
no, but,
yes.
but.
That grade pay is
But Mr.
included.
Naik, I don't understand. Why 12,300 plus 399 plus 100,000 is not used to make it 13,699. Why? Because here you say the basic pay is arrived from where?
Now, lordship, what has been revised is this 12,699. What is PSP? That is not under revision. This amount 12,699, lordship, that amount has been revised. That is reflected in the fitment table. Lordship, kindly come to page 48.
Yes.
Lordship, this table is without any PSP, lordship. This is applicable for all. Lordship,
No,
kindly.
no, Mr. Naik, here the problem arises is this. Understood, it is for all. But the fact that in view of this notification, the PSP becomes a part of the basic pay.
Yes. PSP becomes part of the basic pay for the purpose of calculating house rent allowance, increment, etc., etc.
No.
But their pay, no, lordship, may I again come to the notification, lordship.
Page
25, 23. Lordship, may kindly see 2, serial number 2. In addition to their respective pay and, principalship pay shall be admissible to the officers and staff of the principalship of the Guwahati High Court in addition to their respective pay. That is addition in the pay band and grade pay for determining the basic pay.
So therefore, it is for the basic pay.
Basic pay for what purpose, lordship? The basic pay by adding 1,000 shall be used for the purpose of calculating dearness allowance, house rent allowance.
Then you come
increment,
to
etc.
number 4. The principal seat pay shall be paid as a part of the current salary with effect from 1/8/2000 and the arrear from so and so shall be paid in single installment in so and so. The principal of the so and so and it will be counted for arrears with effect from a month in effect only. So, but here it will be said, categorically said that this will be part of the basic pay.
Yes, basic pay for others, lordship, basic pay is grade pay plus pay band.
You saying your therefore submission is that the dearness allowance, house rent allowance, increment, pension, etc. paid on the basic pay arrived at in the aforesaid manner. So 2 will only apply
3 will
in
apply.
respect to ascertaining what is there below.
Yes, second line of clause 2, lordship, Guwahati High Court, in addition to their respective pay and pay band and grade pay. So for a respective pay in the pay band and grade pay, that will remain the same. But their basic pay will be calculated on the basis of 3 ingredients, that is grade pay in the pay band, grade pay plus PSP. But they are in the same pay band.
Very difficult.
No, lordship, we are for what purpose, lordship, we are calculating the basic pay? For counting the dearness allowance, for counting increment, for counting house rent allowance. So that will not change their position in the fitment table. In addition to their respective pay in the pay band and grade pay.
Now, where can we get this order of the Guwahati High Court? Then we may get some idea because this is being done in pursuance to the order of 4/4/2016. You have it, Mr. Mohanto? We may get an understanding why the PSP is there. Is it a part of the basic package? So I get your submission. Your submission is for the purpose of calculating, bringing into the fitment factor, what is required is to be taken is the basic, the
pay in the pay band.
the pay in the payment plus increment
Increment even not required, Lordship. Lordship may kindly come.
Here you have used the increment. na?
Lord, increment will be subsequently, increment is given, suppose what he was entitled in the year 2016
No, no,
at
no.
the time of
No, no,
appointment.
therefore, you say in this calculation at page 79, what you have added?
Yes,
You have added the
on
pay in the
that,
pay belt
yes,
plus grade pay plus
the here we are, Lordship, calculating the increment.
plus increment.
On the date of increment, that is on 1st of July 2017, what will be his increment? After the increment, this is the amount he will receive.
So therefore, if you see page 79 down below, last but one line, 12,300 is being arrived with 8,000 plus 4,300.
Yes, yes, ma'am.
Pay in the pay belt plus grade pay
Yes,
plus increment,
yes,
which you have adding.
heading,
All these three being added, you are arriving at 12,699 and you are putting this 1,000 separately.
that is
You
principal.
are
pay.
therefore not treating the additional amount of rupees 1,000 for the purpose of applying the fitment factor.
Yes. For the purpose of basic pay, that will be counted. But for the purpose of determining his position in the fitment table, that 1,000 shall not be counted.
Yes, Mr. Mohanto.
My lord. That, my lord, you must be, my lord, highly technical, my lord, I am.
This is not technical. I am relieved.
Your lordship, can
I'm
you see the
telling you, I'm
page 104,
relieved.
my lord, there's a
The
judgment,
simple problem with this pay.
my lord.
The original that they
No, my lord, your lordship.
Like if just one table will clear, Lordship, what she is trying to get, Lordship. At page
it is here only,
1.5, fitment table, Lordship,
86 only.
86.
So what she will get, she will come within the bracket of 13,860.
No, Lordship, in these calculations,
No, you are giving as per 13,050.
yes,
At
that is
number
serial
three.
number 3.
And if she gets the 1,000, it will come nearer to
What she wants,
13,860.
Lordship, 12,699 plus 1,000, that will be 13,699. And if it becomes 13,699, then it will become 13,860. That is serial number 5.
That is
Yes.
35,350.
Yes, that ultimately that is 35,350. That is what she is trying to get,
So therefore, that is what she is trying. I get it.
Lordship.
This matter has become easier because of that day matter. Whole day I spent one matter.
And what we are giving now, Lordship, at serial
That is
number
the serial
3,
number 3.
that is 33,320.
You are giving at serial number 3.
Lordship will kindly take that account, Lordship. 33,320.
Ah.
33,000.
Now you are giving on the basis of serial number 3.
Yes, 33,320. Last column, Lordship, may kindly see the, top, Lordship, grade pay 9400. So this is 33,320 plus 9400 plus 1,000 PSP. That will become 34,320. 3-factor, Lordship. 33,320.
So therefore, with this, you are adding plus 1,000.
To simplify it, Lordship, may kindly come to the last column of serial number 3, 23920 plus 9,400, it becomes 33,320 plus 1,000 PSP, it becomes 34,320. Now, the only issue, Lordship, whether for the purpose of determining what will be her position in the fitment table, whether there is any requirement of adding that 1,000 PSP or not.
The employer has stated it to be, my lord, the High Court has stated that it should be 2 parts, page 65. But if I kindly turn to page 65, the High Court has stated that it,
Let us hear the High Court.
yes, my lord.
Yes, Mr. Mohan, the expert.
No, my lord, actually, this is highly technical. I am unable to understand, my lord, why that is, that only whole problem is.
You
created by
make me
PSP.
understand. You see, this is not the problem. The affidavit is very clear.
My lord.
What they do is, you see, the thing is like this. 8,000 is the grade is the pay in the payment. 8,000. Rate pay is 4,300. Okay. So it comes to 12,300. Plus 1,000 is 13,300. Okay. So there, on the basis of that, a 3% increment,
On basic.
which comes to 399. 399. Now what happens? What they are doing is 8,000 plus 4,300, 12,300 plus 3,399, which is the 3% increment. They are making it 12,699. Okay. Now, for the purpose of increment, he therefore says, we are taking the PSP. That is why it is being done on 13,300.
For the purpose of increment.
For the purpose of increment, we are newly taking the PSP. But for the purpose of applying the fitment factor, you can't get the
And
PSP.
get the
This
fitment
is his submission.
final.
Now, therefore, you have to explain to me, what do you mean by page 23? That is not technical.
Page 23.
What is my submission in this regard?
No, I understand.
All of us were appointed on the same day in the same pay scale. I have been appointed in a different department. He has been appointed in the High Court. But if our pay structure will go in a similar pattern, Lordship.
There the problem arises, Mr. Nayak, because the PSP.
Yes.
The PSP is only given to those who are there working in the principal seat, which shall
Yes.
form a part of his basic pay.
In addition to pay in the pay band plus grade pay.
That is why if it is in addition, it forms a part of the package.
Yes.
So therefore, a person who may be there in the legislative assembly or a person who is working out there in the subordinate court may not get the PSP, or even in an outlying bench, he may not be included out there. Now the question is, simple question out here is whether a PSP can be a part of the basic package for applying the fitment factor. That's the simple question.
But there is no doubt that PSP is the part of the basic pay.
No. What is his submission is this. Kindly come to page 22.
My lord. 23, my lord.
22, 23, whichever you feel like will come.
No, my lord.
23, 23 or 24. Whatever.
My lord.
Now, what he says, this PSP, if you come to serial number 2,
the principal seat pay shall be.
No, serial number 1 also he makes it. The officer and staff of the Guwahati High Court principal seat will be paid a principal seat pay in addition to the existing emoluments, existing pay plus allowance on the following scale. So if a person is in pay band 3, he will get 1,000 rupees.
My lord.
In this case, the person concerned are in PB3. So they get 1,000 rupees. So there it's okay. Now he said, the principal seat pay shall be admissible to the officers and staff of the principal seat of the Guwahati High Court in addition to their respective pay in the pay band and grade pay for determining the basic pay. Meaning, basic pay is equals to pay in the pay band plus grade pay plus PSP. Now, therefore, you again find it out. 8,000 pay in the pay band, grade pay 4,300, PSP 1,000. So it is on 13,300. Now, if you see the submission of Mr. Nayak is this. This 13,300 is only applicable for these factors, meaning thereby for fixation of the DLNS allowance, house rent allowance, increment, pension, etc. will be paid on the basic pay arrived in the aforesaid manner. He therefore submits that as the application of the fitment factor is not there, so therefore it would not apply. That is his submission.
So
Like it.
So now question arise, my lord, whether that basic pay that it will be get any impact in fitment factor.
Now, what has happened? How the fitment factor apply? The fitment factor normally applies because the 7-pay commission,
My lord.
the fitment factor is 1.86. So whatever you get, you multiply, earlier you have got, you multiply by 1.86, you get
My
the
lord.
actual salary. For their convenience, they had made fitment tables, which is there in terms with Schedule 7. So these fitment tables are in this table, it categorically mentions, as per them, if you exclude the 1,000, this is
Then
his submission. 13,000, 12,699.
Correct.
Plus 1,000 is, he says that my fitment factor has to be applied in terms with 13,699. And as the nearest, as per the rules, is 13,860, I should be getting 35,300, whatever. His case is, it has to be based on 12,699 without taking out the PSP, and this is nearer to 13,050, and therefore his salary would be 34,420.
so as per clause
Now
two, that
explain.
no, my lord, actually that technical point, my lord, actually what he explained, my lord, if you're
I'm not on the technicality. Therefore, you say
my lord,
as to whether the PSP is to be included for the computation of the basic pay,
the computation of the basic pay, my lord, is correct.
or
my lord.
is it only
No.
limited to the dearness allowance, house rent allowance, increment, pension, etc.? This is the thing.
My submission, Lordship, for that purpose, Lordship, we have no other instrument other than this notification of 16 August 2016. This is the only notification, Lordship, so far as
No,
PSP is concerned.
basic pay, my lord,
Not
include
beyond that.
PSP, there is no doubt about it. Basic pay, PSP included in basic pay by a judgment of the High Court, my lord. And the day notification, my lord, they publish one after the judgment, my lord.
Where is the judgment?
Judgment, my lord, they probably connect to, huh?
Yes, my lord,
Let
page
us see.
97.
Page,
Page 97 of this, my lord, additional affidavit.
Page
Affidavit in reply, my lord.
90?
97, my lord.
Which judgment?
That is, my lord, Ashish Bhuya's judgment, my lord. And in the,
WPC 1.
yeah, WP that is mentioned here, my lord. In page 23, my lord, that WPC 1724 2015, that is mentioned. And that order, my lord, your lordship will find page 97 and 11 portion is, I think, 104.
Page?
Page 104, my lord, is
You
11
come
portion.
up with
It
different
starts from
pages.
197, my lord.
Okay, what does this court say? Let us see how. It is not with the Supreme Court. Guwahati High Court employees. Now, tell me, what has happened? This PSP is being given to everybody. Okay. Now, there were many appointments subsequently made for others also.
Others, yes.
How are they treating them?
In respect,
Are they including the PSP for that purpose?
in respect of similarly situated persons like computer assistants.
They have given.
They have been given
As PSP
as
with,
PSP by including PSP. That is the specific instruction.
how do you say so?
My lord, a similar repetition, my lord, that repetition has also been annexed here, my lord.
They have annexed the judgment, my lord. Judgment is in there.
Prior to that, my lord, one judgment has been annexed at page 109.
Wait, following the enforcement order, this court, a notification was issued by the Judicial Department of the Fund providing municipal pay.
Page 103. Computer system.
Computer assistant is our page where they are.
No, the click method है. अगर click method चाहिए था. Treatment table 1,000 number. Okay. So that was really- এটা আলাদা বেশি হয়, বইটা। মানে contradictory হয়ে যাবে না? আমি মনে করি। বুঝলেন, পড়েছে না? তা treatment table পড়েছে। তাহলে এটা ফেলে বলে
What paragraph?
paragraph my lord 60 104 my lord page 16
That I read it.
para 10 page 104 my lord.
That I read it.
No my lord, now I came to know that earlier my lord, in another writ petition the stand taken by the finance department has been agreed by the high court, so I cannot take a different stand, but in that case my lord, my lord Lanet Fan is appearing.
This PSP 1000 will not come into play for calculation in the fitment table.
Is it?
Yes.
So there is a.
How do you know?
Milord, the reason is that, Milord, the fitment table is one. It has been provided by the pay commission and ROP rule. If we have to take 1000, there has to be a new fitment table only for the high court employees. The fitment table is for the purpose that the from pre-revised, from transformation, from pre-revised to revised. How it will come? This is my pre-revised pay and grade pay, and this is my revised one, pay. That is the only, it's basically a calculation method of easy coming or easy transformation of the pay scale. Now, in that case, our stand was that this PSP, what my learned senior brother has said, it is only for dearness allowance and all these things. For the purpose of revision of pay under the ROP rule, this PSP will not come. Basic pay and grade pay. Then respective fitment table will be able to ascertain the that particular pay and grade pay, the total amount in the fitment table, and that will be converted to whatever the 6 CPC or 7 CPC or whatever is the amount fixed. And if we don't get the exact amount, in most of the cases we get the exact pay, because there is a symmetry, because this was done by the pay commission taking into consideration the
Or
pre-revised.
in other words, you are therefore submitting that the department have only mentioned a particular amount as the PSP. Now, moment you include that, no, the moment you include it within the purview of that, there's no PSP.
Sorry.
There wouldn't be no PSP.
Yes, in a sense.
So therefore, there would not be any PSP. What is therefore the decision on 4/4/2016 is of relevance? Because on the basis of 4/4/2016, it has been mentioned.
That was, so far as I remember, Milord, that was an interim order passed in that particular petition by which
Change the financial.
No,
by which PSP was extended.
4/4/2016 is an order being passed by the High Court
Yes,
in WPC number 1725 of 2015.
yes,
Now, in that case, there was a direction to give a PSP.
yes.
Now, pursuant thereto, it was said that in each pen, there will be a PSP
Yes,
of 500, 750, 1,000, 1,250. So, once you add the PSP within the purview for the applying the Fitbit factor, can there be any further PSP then?
No,
I hope you are making,
I have understood, Milo. If I just place it in this
because
way,
here it means a PSP.
here, the PSP, the whole idea of PSP is that not the, Milo, the employees of the Guwahati High Court, Milo, eroded work is there, so there has to be an additional pay for the employees of the principal seat. So it's an additional amount has been given as a PSP to the High Court employees only. No other, either subordinate court or the government, nobody gets this pay. So it's an additional amount paid.
But tell me, I'm just asking you this.
Yes, sir. Yes. Sorry.
This was in the year 2016.
Yes.
We are in the year 2025.
Yes.
Every 10 years, normally there is a revision, which is here now we are going ahead. Is there a scope of enhancing of the PSP? How do you enhance the PSP? Because there, you see, are we to say another 20 years down the line, or with the 8-pay commission looming nearby?
PSP is not part of any pay commission.
No, it's okay.
Huh.
Looming nearby, so it will remain as 1,000.
It has to, no.
No, that's
No,
really, my lord,
that is
2013, my lord, revision of pay rule has been made by the High Court. That was not been approved by the government, my lord. That is also going on. Because they say that you are getting, we have a shortage of fund, that's why not approved. And that probably matter was probably listed few days back. They say that, my lord, you are getting a PSP. That's why another increment in
So therefore, the PSP which is being given
yes, 2013.
has to also commensurate.
If
This is being
near
done
future-
on 4/4/2016. No, this is a very important aspect.
Yes, yes.
4/4/2016, when this is being done, then we are concerned with the 5th-pay commission, a 6th-pay commission. Because at that point of time, the 6th-pay commission was holding the field.
Now 17.
The 7th came only on 17/3/2017 with effect from 1/4/2016. Okay. So this fixation was done at a time when the 6th-pay commission was holding the field. With a salary of rupees 8,000 to 13,000, you are putting a PSP of rupees 1,000.
That is constant.
Okay. Now with a salary of 30, which is being now made with 22,000 or 33,000 onwards to 70 to 90,000 or 70,000, we are still having a PSP of 1,000. How does it make sense?
That's the difference.
That is the
In my, Milord, what my understanding is.
my personal feeling, Lord. There is every scope of enhancement of this PSP, Lord. If the issue is raised before the appropriate authority, that is another issue. But this should not be looked into as just rupees 1,000, Lord. Because other than this rupees 1,000, so far as other factors are concerned, house rent, increment, etc.
No, Mr. Naik, you have to understand. 390 rupees in 2016, prior to, I'm saying therefore, prior to the coming into effect of the 7th-pay commission was a good amount on increment.
So that it
But the
becomes-
next increment when you have in 2017, it would obviously phenomenally go high. So therefore, can you say that the PSP would remain stagnant? And if you don't bring it within the factor of the great pay and all, High Court understanding that I'm not on the question of whether the High Court accepts or not. I'm not bothered with that. But the question, because the High Court on the administrative side may do whatever may be, as your district judges keeps on doing. But the question out here is on the judicial side, can we say that there will be a stagnation of the PSP of rupees 1,000, which may have no meaning once with effect from 1/4/2016, you clearly see it is 8,000 is the basic pay. Against that, you are giving 1,000, which is 1/8. 18?
Got it.
Against 33,000, you are giving 1,000. It is 138. And with the looming of the 8,000 period of the year. So a person who is being working out here, there's an increase by manifold. Are you therefore justified to say that this would not be made a part of it? The state government may not agree.
If I
That
have,
is different.
if I have understood PSP correctly, Lord, PSP is a thing which has been given to the principals and employees uh, in pursuance to a separate policy decision. It doesn't come with the normal pay revision thing, my lord. This was given in pursuant to a separate policy decision. That's why, my lord, since 2016, there is no further revision of
Mr.
this.
Das, you have to understand a very important factor. This PSP is not given on the basis of a policy decision. Kindly
Direction
appreciate.
of the High Court.
This is done under 229(2) with the approval of the government, of the governor. So therefore, when it becomes an approval of the governor, it gets the ear of the legislative. The moment there is an approval of the governor, it becomes a part of the package. Well, see 229(2).
I understand, my lord. I understand.
So
But
therefore,
it's
how
more
are you
like a-
saying
it's
the
more like a-
PSP will be outside? Because otherwise the PSP may not increase.
We always contact.
How do you fix the PSP then? How do you increase the PSP? I mean, what is your basis? That today, okay, today we are thinking 5,000. Let us make it again 1.8. So let this PSP, which is earlier 1.8, now it is 138, we again make it 1.8. Are you therefore required every time for the High Court to make, the Chief Justice to make that and get the approval? High Court in the administrative side may
Yes.
do many things. High Court, there are the different permutation and combination. But here, on the judicial side is different.
Whatever be the case.
There is at least scope for enhancement of. the-
How? No. How do you enhance? Meaning thereby, do you mean to say that the Chief Justice will again make a rule
Not that is what-
and again make a rule and request, and on the basis of that rule, they are going to do it?
That rule is already there, Lord. Only issue,
No.
what extent it. should
No,
be
no, Mr. Naik, that rule has not yet been done since 2013.
Yes.
That is the subject matter of another
Another-
petition.
My sufficient pay logic, when the payment was 8,000 to 35,000, then it was fixed as 1,000. Subsequently, it enhanced to 22,000 to 97,000. In that enhanced payment also, it remained the same 1,000.
So how do you increase? Because earlier, which was 1.8, now it has become 128.
This is why I'm submitting, although it's not my office's. What I'm submitting, if an appropriate proposal comes lordship, that can be decided by the authorities, both at the administration and the High Court. This is, I mean, government and High Court. But that should not be made an basis for coming to a conclusion that just because that amount is not increasing, or that amount.
No, no, not the, no, Mr. Naik, I am not on that basis. Here, the power which is being exercised is in terms with Article 229(2).
292.
And the governor being permitting this pay is permitting the enhancement in the pay. You see that? Therefore, there are many Supreme Court judgments also to the effect that 229(2) gives the power to the Chief Justice not only to make rules as regards many other aspects, but also as regards pay. But if it is a case of pay, pension, leave encashment and all, then the permission, it has to be done with the approval, and the governor has to approve. Now the Supreme Court later on say that this approval of the governor means the approval of the government. So therefore, with the governor issuing this notification that they are getting this PSP, wouldn't be a part of his package. That is my case, although he has not made the submission.
Whatever be the case, because whatever be the deliberation in the writ petition or whatever be the decision of the Honorable Chief Justice under Article 229(2), the 16 August 2016 is the notification issued by which this aspect is guided.
Thereby, what
So-
has happened, you see, what has happened is the pay has been increased.
No, I am not on that. What I am on is that it specifically provides, as my learned brother has read, DNS allowance, house rent allowance, increment, pension, etc. will be paid on the basis on the basic pay arrived at in the aforesaid manner. Here, the revised pay is not there. We'll have to go by this notification.
No,
Because whatever
you,
the
no, you cannot go into that revised pay because of the fact that this was done when that notification of 2000, that notification had not come.
Yes.
You see, that notification 7P commission came only on 17/3/2017, giving it effect from 1/4. So therefore, by virtue of the proviso to Article 229(2), it has been increased by bringing that PSP, which is paid a part of the salary.
I have my reservation.
You always have.
I don't always have, my lord, in
You
most
have
of the
that.
matters, my lord. I don't have reservation, but in.
But
this
how
particular
do you say about the power under ER? You see,
No, no,
no. No, this is 229.
I understand.
You
but-
see, this is an approval being made by the government on the basis of the 229.
Lordship is absolutely correct. I understand. But while regulating the issue of PSP, how the PSP will affect, what will be the consequences? The final outcome is this notification. When this notification says that the basic pay that has arrived above will be with regard to only this thing, can we go beyond that?
Meaning?
Basic pay, which has been arrived at by applying the aforesaid method, that is pay in the pay band, grade pay, and PSP. That will be
No, no,
taken into
are you
account.
therefore saying that the first portion of clause 2, which says how the basic pay would be arrived at, is
That is what
controlled?
my
No, no.
brother is
Are
also
you
submitting,
submitting that the first portion of how the basic pay would be involved is
Yes.
being mentioned in clause 2
Yes.
is being controlled by the second portion of clause 2?
Exactly.
Sick pay is not for the purpose of determining its position in the fitment table. Basic pay is for the purpose of counting, calculating what will be the house rent allowance, what will be the upper increment, for that purpose only. In case of lordship, other employees, basic pay is pay in the pay band plus grade pay. And on that basis, only house rent allowance is calculated. But in case of high court employees, basic house rent allowance is calculated on the basis of 3 ingredients. Pay in the pay
Now
That is
show
the
me
benefit
where
they are
in the
getting.
copies what they have done, copies,
My lord,
copies.
computer assistant, they have been paid, my lord.
Where?
But I have annexed that order.
Page?
Paid, my lord, it is 130.
130.
Additional affidavit.
130 is the judgment. What 130 is the judgment? Which paragraph? Petitioner affidavit filed on when?
Page number. 103.
The council, are you going to say, do you know that? When was the additional affidavit filed?
Yes, yes, that is 103.
103.
Should I also adjourn this matter cyanide on the ground that the council is not prepared?
No, that's my.
Is this the matter by which, are you not, you have been asking this court to have fixed this matter, and you have not been able to prepare and fix this as per the list? Is it so difficult for you? Is this the assistance this court gets from you? Where is that?
103, my lord. That's wrongly written, my lord, some,
What 103?
in my page, it means 130.
So you don't know. Do you mean to say that I should appoint an amicus? As you are not in a position to argue the matter properly? You don't know how to, you have been asking this court, they kindly take up the matter, kindly take up the matter. What is wrong with you? Disgusting state of affairs. The counsel for the petitioner being not properly ready with the matter. List this matter again for hearing on 29th of May 2025. 29th of May 2025. The petitioner would be at liberty to engage any other counsel for more for more professionally placing the materials before the court.